All right, so we're on the record and docket. This is a Judge Ward probable cause conference. We're on the record in 24-00141. That is people of the state of Michigan versus Matthew Martin. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people, stepping in for EPA George and
Ms. Robinson.
Erin Robinson, Assistant Public Defender for Mr. Martin.
And sir, you are Matthew Martin, is that correct?
Correct.
All right, this is the time set for a probable cause conference. Ms. Wilson, how are we going to proceed, or would you like to defer?
Thank you, Your Honor. It's my understanding that we're leaving this for preliminary exam.
Is that a fair statement, Ms. Robinson?
Your Honor, actually, at this time, we would be requesting a good cause adjournment. Mr. Feigelson is handling another of Mr. Martin's matters up in circuit court, and he will be in trial next week. He'll also be taking over this case. So we would be requesting a good cause adjournment because of that.
So my understanding is Mr. Feigelson stepping in, and he's in trial next week. And he's correct. Also got, does he have a Mr. Martin case in circuit court?
That's what it sounds like. The people have no objection to an adjournment, just as long as the adjournment is for the prelim.
Okay. So we'll adjourn for good cause. For PD counsel Feigelson, who has a conflict. Do we have a new date for this, Judge Ward?
February 23rd at 8:30.
So we'll be set for February 23rd at 8:30. So, and we'll adjourn for good cause based on the conflict. So Mr. Martin, your preliminary examination will be February 23rd at 8:30 with public defender Stephen Feigelson. We've adjourned for good cause, so you've not waived any of your rights today. Anything else for the record in 24-00141, Ms. Wilson?
Nothing from the people, Your Honor.
Ms. Robinson?
No, Your Honor, thank you.
All right, Mr. Martin, you're all set. Thank you for your appearance today.
And then I believe we're ready on Ms. Lawton's case, so I will defer to her for what she wants to proceed on next.
How are you, Ms. Lawton?
Well, Judge, how are you?
I'm good. What case do you have?
Do Mr. Baker?
It's our enough. Parker?
Parker.
Parker. Mr. Green, how are you?
I'm great, Your Honor. How you doing?
I'm good. I am good. All right, so we're on the record in docket 23-03581. That is people of the state of Michigan versus Nathan Barker. Will the parties please introduce themselves for the record? Ms. Lawton.
Morning, Your Honor. Jennifer Lawton on behalf of the people.
Mr. Green.
Thank you, Your Honor. Vince Green on behalf of the defendant, Nathan Barker, who's standing to my right.
And sir, you are Nathan Barker, is that correct?
Yes, Your Honor.
Right, thank you. This is the time set for preliminary examination today. Ms. Lawton, how are we proceeding?
It's my understanding that Mr. Barker will be unconditionally waiving his right to that preliminary exam. People also unconditionally waive their right to an exam.
All right. And is that a fair and accurate statement? Mr. Green, negotiations are continuing in circuit court.
That's correct, Your
That's
Honor.
correct.
May I inquire of your client of his waiver, Mr. Green?
Yes, Your Honor.
All right, Mr. Barker, you have the right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented by Attorney Vince Green today, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. You understand that, sir?
Yes, sir.
It is my understanding, it is your wish today to waive your right to a preliminary examination. So this case will be done in district court. It'll be bound over to circuit court as charged with negotiations between Mr. Green and Ms. Lawton to continue. Is that correct?
Yes, Your Honor.
So it is your wish today to waive your right to a prelim.
Yes, Your Honor.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. Ms. Lawton, you indicated previously that the people also waived their right to a prelim.
That's accurate, Judge.
All right, I will provide counsel with the bind over to sign. There's one place. All right, so I'm in possession of the file, and I will sign the bind over. It was previously signed by council. Examination was waived on today's date, in the 2nd of February. And I will sign the document to that effect. Mr. Barker, please keep in contact with your attorney, Vince Green. Your time in district court is done. You'll get your next date in circuit court, probably in the next 2 weeks, depending, from Mr. Green. Okay, Matt? Okay, sir?
Yes, sir.
All right. Anything else for the record in 23-03-581, Ms. Lawton?
Nothing else from the people.
Mr. Green?
None from the defense, Your Honor.
All right, Mr. Barker, your next day will be in circuit court. Thank you. Thank you, Mr. Green.
Thanks.
Thanks, Judge. Good seeing you.
Who's next? Ms. Wilson or Lawton?
Yeah, it looks like
I just
Miss
lost-
Donnelly
I just lost Miss Donnelly.
stepped out.
Okay, I saw Miss Donnelly in here. Oh, is she? I think she's in a breakout room.
Do we know who the individual under SCSO
That's
is?
Luke Spear.
Would the individual under the name Darian, with the moniker Darian on the Zoom court, could you please identify yourself? You'll have to unmute.
Talking, let me see what's going on.
Darion.
Is that Darian Ray?
Yeah, I'm here. Hello.
All right, so you're set for prelim on my doc for 8:30. Is that correct? Darian Ray?
Yes, Darian Ray.
All right. All right.
So,
All right, Mr. Ray, we'll call your case in relation to docket 24-00104. That's People of the State of Michigan versus Darian Ray. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
And Mr. Ray, you are unrepresented by counsel today, is that correct?
Correct.
And you were told at your probable cause conference that this was a live hearing, so you were to be here live?
You said I was supposed to be here live?
Yeah, on the 6th floor of the city hall, you were told at the probable cause conference to be here live for your preliminary examination.
I didn't have it because it got pushed back because I didn't have a lawyer. So
Right, but that doesn't mean that that doesn't mean you're not supposed to be here live.
I thought it was
If I
online
may.
again. All right.
Ms. Wilson.
We did in fact have the probable cause conference and we set this for a prelim to protect the 21 days because it was under our understanding that Mr. Ray was in the process of getting an attorney.
That's what
He
I know.
was told at the last hearing to appear in person.
Mr. Ray, you were seeking an attorney last week, and so we left it on for prelim now. and for a week for you to continue seeking an attorney, and you were told to be here in person. You don't have a lawyer and you're not in person. So, Mr. Ray, how do you account for that?
I didn't know I was supposed to be in person, but I can come right now. It's no problem.
All right, well, we'll be here all morning, so we'll wait for your appearance.
Okay, yeah, I'll be there shortly. Thanks.
All right, thank you.
Yep.
Do you have any pieces? No, just,
Yeah, I'm gonna talk to him and go over this. I wasn't able, I didn't have these.
Let's see.
I will say that.
Sir, in the Ingham County Post, would you please identify yourself?
Well, actually.
Omar Thompson.
Omar Thompson.
That's what his phone is.
That's his
All
name, but I at least have to.
Just one, she and Judge Simmons.
Yeah.
All right, Mr. Schimpf, are you with the AG's office on Mr. Elliott?
Yes,
Okay. And then Mr. Goodrich, you're also on that case?
Yes, I am.
All right, and then where's Mr. Elliott?
He is in jail. He is.
All right, so he needs to be brought over
No, he's scheduled to be on
Polycom?
on Polycom with you at 8:30.
All right. We got a lot to be on Polycom, so we'll just wait his appearance, okay? And then I'll call that case once he shows up, because I think Mr. Thompson's here right now, but I don't see Mr. Elliott. So I'll call that case as soon as he shows up on Polycom.
Okay, and Your Honor, would it be acceptable to waive his exam today on that matter? If we
Absolutely,
Okay,
yes.
so I'll just need to talk with Mr. Elliott for a minute, and that's
All right.
likely how we will proceed.
So, Mr. Goodrich, would you like to be put, you're both in room 2 already. You can go back to room 2 to talk to Mr. Elliott if you'd like some privacy.
Yes, that's fine.
Oh, but Mr. Schimpf is with the AG. All right, so we're on the record in docket 23-01766. That is a probable cause conference on Judge Judge Simmons' docket. Will the parties please introduce themselves to the record? People versus Jessica Alicia, Miss Lawton.
Good morning, Your Honor. Jennifer Lawton on behalf of the people.
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Jessica Alicia, who is appearing separately by video.
And ma'am, you are Jessica Alicia, is that correct?
That's correct, Your Honor.
Okay, and you can hear me all right, Miss Alicia?
Yes, I can, Your Honor.
All right, thank you. This is the time set for a probable cause conference in front of Judge Simmons. Miss Lawton, how we proceed?
Your Honor, I will defer to Ms. Donnelly. I believe that she is going to be requesting an adjournment. It's my understanding that Ms. Alicia is an inpatient program. The people have no objection to an adjournment for that reason, and so that Ms. Donnelly and I can continue with some negotiations.
All right, is it your understanding, is Miss Alicia going to waive? I don't think she's previously waived her right to a 21-day.
No, Your Honor, this is her first probable cause conference. We would ask that the court could allow her to waive for 21 days and then adjourn the probable cause conference. She has some cases out in East Lansing that we also need to resolve, so we would like to set for a probable cause conference. We're not intending to meet witnesses or anything.
All right, so the waiver of the 21-day rule and adjourn for negotiations to continue and discovery purposes, or just negotiations?
Just negotiation.
Just negotiations to continue. Ms. Donnelly, may I inquire of Ms. Alicia of her waiver of the 21-day rule?
Yes, Your Honor, thank you.
Ms. Alicia, you understand you have a right to a prelim within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Sarah Donnelly. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, ma'am?
Yes, Your Honor.
It is your wish today to waive your right to a preliminary examination only within that 21-day period. You wouldn't be waiving your right to a prelim in general, just within that 21-day period. So negotiations can continue between Ms. Lawton and Ms. Donnelly. Is that your wish today, ma'am?
Yes, Your Honor.
Okay. And you also waive your right to a prelim within 21 days?
Yes, Your Honor.
All right. I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And we will reset for probable cause conference.
I did not get those dates from that. It sounds like it was a fake.
All right, we'll set it for PCC on a prelim. Then we can go from there. Because you want to reset for PCC, don't you?
Please, yes.
Yeah. So if you have a prelim date, that's, we'll just set it there.
March 21st at 9.
March 21st at 9 o'clock. We'll reset it for prelim
Am I setting it at the exam date?
at PCC. And it will leave the exam date for for the judge to consider their docket.
Okay.
Okay. So March 21st at 9 a.m. for PCC. At request of counsel. And then on that date, you can revisit when you're going to set it for prelim. Anything else for the record? 23-01766, Ms. Lawton.
Nothing else from the people. Thank you.
Ms. Dunn.
Not from defense.
All right, Ms. Alcia, we reset this for March 21st at 9 a.m. You should, for probable cause conference, you should get notice sent to that Deer Path address. All right, ma'am?
Okay, perfect. Thank you, Your Honor.
All right, thank you. That's all for the record in that file. Now we should be ready on Lackey.
Yep.
Okay. So we're on the record in docket 23-02888. People of the state of Michigan versus Jada Lackey. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Reed.
Yes, good morning, Your Honor. May it please the court, Daniel Reed, P number 30965, appearing on behalf of Ms. Lackey. Ms. Lackey, state your name for the record, please.
Jada Lackey.
Thank you.
All right. This is the time set for a preliminary examination, I believe, today.
Correct, Your Honor.
Ms. Wilson, how we proceed?
Thank you, Your Honor. At the last hearing, we adjourned this so the people could get some additional time to request some additional evidence. The people have made multiple requests for the evidence, and we have not heard one way or the other if it's even been looked into. We don't have the complaining witness here today, so I anticipate a motion to dismiss from the defense.
All right, Mr. Reed.
May it please the court, Your Honor, as she has indicated for the record, this matter was set for preliminary exam. We are ready to proceed at this time. Respectfully, based upon our statements, we would ask this court to dismiss this matter.
So we're starting with, I also have a
There's a bond violation.
bond violation, but in regards to, we'll start with the prelim and then go to the bond violation. It appears the people are unable to proceed, and the motion to dismiss from the defense, based on representations of counsel, it appears that the witnesses have been subpoenaed, have not come today, and there's been no contact between the prosecutor's office and the witnesses in the case. I'm in possession of an order of acquittal, or what we call a nollie pros in this matter, on docket 23-02-888, based on counsel's representations and requests for motion. I'll assign the order for February 2nd, 2024. This means that this case is dismissed without prejudice, which means the people could reissue if they choose to, but for our purposes today, the case is dismissed. All right, ma'am?
Okay, thank you.
Thank you. And then similarly in regards to
I
no
would leave it to the
contact,
court's discretion. I believe is the bond violation a no contact, or is it a fail to appear?
I believe it is a no contact.
Okay, I would leave it to the court's discretion.
Mr. Reed.
We'd indicate there's been no contact by my client. I don't understand the violation itself. We'd ask the violation be dismissed also.
All right. Well, based on the inability of the people to proceed on the matter, complaining witnesses going to indicate this. Appear. Complaining victim failed to appear. Bond violation is dismissed.
Thank you, Your Honor. We appreciate the court and the prosecution.
All right.
Very professional. Thank you.
Okay, thank you, Mr. Reed. Have a safe trip back, okay?
Thank you, sir. I appreciate that.
Thank you,
Should we
Mr.
wait
Reed.
outside for the paperwork for the dismissal?
Yes, you can get a copy of the nollie pros.
I would love that.
Luke Spears.
Your Honor, I believe we're ready on Spears. That is the Judge Simmons case.
Right, thank you. Is that Luke Spear?
Yes, Your Honor.
He is appearing, he was on Zoom for Shiawassee.
Thank you. You think I'm cute?
Is he on? Do we have a Luke? Is your client here by Shiawassee?
He was under SCSO, I believe.
Oh,
Yeah, I just talked to him at the breakdown. I don't know if he
he's on his way back.
came back yet.
That's the thing. He's on his way.
Yes. Nice to meet you. Yeah, we have, yeah. Yes, and I've given it to. And for the city, whenever they have time.
Do they have to push the button over there? All right, so we're on the record in docket 23-03742. That is people of the state of Michigan versus Luke Spear. Will the parties please introduce themselves for the record? Ms. Petrosky.
Thank you, Your Honor. Assistant Prosecutor Paige Petrosky on behalf of the people.
Mr. Samuels.
Matthew Samuels on behalf of Mr. Spear, who is present via Zoom from the Shiawassee County Jail.
And sir, you are Luke Spear, is that correct?
Correct.
Okay, and you can hear me all right, Mr. Spear?
Yes, sir.
Thank you. This is the time set for a probable cause conference. Ms. Petrosky, how we proceed?
Thank you, Your Honor. It's my understanding that defendant would be waiving his 21 days for the preliminary examination.
Requesting an adjournment?
Yes,
We will
sorry.
be requesting I believe, possible 3-week adjournment. The reason being is Mr. Spear is located in Shiawassee Jail. His next court date is until March, so there. And I wanted some time to talk to him as I was just appointed in this case less than a week ago. And he is willing to do that and willing to voluntarily waive his 21 days.
All right. And do you want this reset for prelim or probable cause?
I'm fine with the right to-
So we can go right
Decide
to,
to waive.
we can go right to prelim?
Yeah, we.
All right.
Prelim.
Mr. Samuels, may I inquire of your client, Mr. Spear, of his waiver of the 21-day rule?
Absolutely.
All right. Mr. Spear, you understand you have a right to a preliminary examination within 21 days of your date of arraignment today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. It is my understanding that you are represented by Mr. Samuels today, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding it is your wish to waive your right to a preliminary examination only within that 21-day period. So Mr. Samuels can continue to negotiate and zealously advocate on your behalf. You would not be waiving your right to a prelim in general, only to that prelim within 21 days. Is it your right? Is it your wish today to waive your right to a prelim within that 21-day period?
Yes, Your Honor.
Do the people also waive their right to a prelim within 21 days?
Yes, you would.
So I find the waiver of the preliminary examination, for the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And I will grant the adjournment, the request for adjournment based on negotiations to continue. And we will set this for over 3 weeks out. Is that correct?
Yes.
Yeah, at least 3 weeks. The reason being is I'm out of town on the 16th.
Right.
So.
And then, and we have to make sure Mr. Spear is brought out for the prelim. March 27th.
22nd.
It's 22nd. At what time?
9 o'clock.
At 9 o'clock. And then Mr. Spear is currently in Shiawassee. Is that my understanding?
Yes.
Okay.
Your Honor, since we are that far out, I'm not exactly sure how to address this. What I'm concerned is that Mr. Spear is out here on a PR bond and not earning any time.
Do you want me to set some, so he's got a PR bond, that's right, the 5,000 PR.
I don't
But
think.
if I set a bond, he can collect some time on this.
Yeah, the issue is that he is going to court on the 3rd. And if he is bonded out on the 3rd, which he said may be a possibility, I don't want that to, I would still like him to be released.
Right.
On that. So that's kind of where it is. Mr. Spear, do you have any comments towards that?
I just prefer to keep my PR bond as is because
All right.
I'm working on getting bonded out here every day.
All right.
And you do understand that you are not earning any time while on the PR bond, correct?
Correct.
In this case.
Yes, sir. I understand.
All right. Thank you, Mr. Samuel. All right. So I'll leave bond as is at 5,000 PR pursuant to the request, to the set by the magistrate, I believe. Anything else on the record in 2303-742? Ms. Petrosky.
Nothing from the people.
Mr. Samuel.
No, I just want to say, Mr. Spear, if you do bond out, you have court on March 22nd, and you need to make sure you can get in contact with me or the courts.
Yes, sir. I'll be
All
in
right.
touch.
Thank you. That's all for the record in that file. Thank you, everybody, for your appearance.
Thank you, Hunter.
That was- Sir, on the iPhone, would you identify yourself?
As long as.
You're in a white t-shirt?
Here, third,
I didn't get the last name.
Yeah, say your name again, sir.
Harry Jackson, third.
Good morning, Your Honor. Harry Jackson is the Judge Simmons case set for PCC.
All right, Mr. Abbott and Mr. Jackson will call your case. We're on the record in 2400148. That is People of the State of Michigan versus Harry Jackson. Will the parties please introduce themselves to the record? Ms. Petrosky.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Mr. Abbott.
Good morning, Your Honor. John Abbott with the Public Defender's Office representing Mr. Jackson. We both appear by video today.
And sir, you are Harry Jackson, is that correct?
Yes, sir.
All right, and you can hear me all right, Mr. Jackson?
Yes, sir.
All right, this is the time set for a probable cause conference in front of Judge Simmons. Is that correct?
Yes.
Okay. Ms. Petrosky, how we proceed?
I would defer to defense.
Mr. Abbott, how we proceed?
Your Honor, having received no offer from the prosecutor, and I have spoken to Mr. Jackson about the case, we'd like to leave this on for a preliminary exam.
All right. And that's a fair statement, Ms. Petrosky.
That's correct, Your Honor.
So we'll leave on for preliminary examination for February 9th at 9 o'clock. All right, so Mr. Jackson, that'll be a live in-person hearing on the 6th floor of City Hall, Lansing on February 9th at 9 o'clock. You got that date, sir?
Yes, sir.
All right. Anything else for the record in docket 2400148, Ms. Petrosky?
Nothing from the people.
Mr. Abbott?
Nothing from the defense. Thank you.
All right, thank you. Mr. Jackson, Ms. Judge Simmons will see you next week on February 9th. You're all set. Thank you for your appearance today. All right, Ms. Wanji, we'll call your case with Mr. Thompson.
Okay, thank you, Your Honor.
All right. So we're on the record and Ms. Petrosky, that's your case.
Yes, Your Honor.
We're on the record in docket 2302979. That's People of the State of Michigan versus Omar Thompson. Will the parties please introduce themselves for the record? Ms. Petrosky.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Ms. Wanji.
Daniel Piwanj, Assistant Public Defense Office for Mr. Thompson, who's appearing by
All
Zoom.
right. Thank you. And sir, you are Omar Thompson, is that correct?
Yes, Your Honor.
All right. You can hear me all right, Mr. Thompson?
Yes, Your Honor.
All right, thank you. This is the time set for a probable cause conference. Ms. Petrosky, how are we proceeding?
I would defer to Ms. Wanji.
Ms. Wanji, how are we proceeding today?
And we're just going to leave it for next week, but we would like to address bond.
All right. So we'll leave on for preliminary examination for February 9th at 9 a.m. Mr. Thompson, that'll be a live in person on February 9th at 9 a.m. You'll be present with Ms. Wanji. Anything else concerning the date and time, Ms. Petrosky?
No, Your Honor.
Ms. Wanji, any questions? And then I'll let you go into your motion for bond modification.
I have no further questions, Your Honor. For the bond, there was, at the time of the arraignment, there was some information regarding my client saying that he had some failure to appear. I did check on that, and I don't see anything that show that he has a failure to appear. He was he has some he really has to be out at this time because there is a concern that he may lost all his belongings. There was an order of eviction, and his landlord has to get his stuff out since yesterday, and my client really needs to come to go out, to be out to take care of his belongings. You know, he understand that there would be some conditions regarding his bond, and he's willing to abide by those. There was also some information regarding threat to the alleged victim. There was no threat, and I don't think that my client, this is the first time that my client is charged with domestic violence or assaultive behavior. And so at this time, because we believe that my client is not a threat to the community, that he has failed to appear, we will respectfully ask that he be released on bond, PR bond, if possible, Your Honor.
Thank you, Ms. Petrosky.
The people take no position on bond. However, I misspoke earlier. I wanted, as far as scheduling goes, I was informed by Officer Craig Fleeser. He'll be unavailable on the February 9th preliminary examination date because he'll be doing military training. So the people will be asking for good cause during that date.
All right, so that February 9th date is not a good date for you.
Correct.
And you're requesting a good cause adjournment for another date. So the prosecutor has a witness who has a conflict. I will grant a good cause adjournment. And get a new date based on the good cause adjournment. So date post February 9th. Ooh, that's quite the time.
That's all they gave me, all dates in March.
They give you February 9th or March 20th.
February 9th was never a date, that was just the original exam. The dates that Eddie gave me are all in March, end of March.
So the next possible date is in March, right? That's what I'm being told.
Yeah, that's, she would probably know the judge's schedule better than I would.
All right, so what's the date?
March 22nd at 9:30.
So this is adjourned to March 22nd at 9:30. I am going to modify the bond based on counsel's representations. I do have a bond recommendation. So this is adjourned for good cause. So Ms. Wanji, your client waives no rights in this matter. We do have a conflict from one of the prosecutor's witnesses. And so I'm going to adjourn it to March 22nd, 2024 at 9:30. I am going to readdress bond for the new information that there's no history of fail to appear. I do have a bond recommendation indicating that this is a crime of violence. Obviously, it's assault GBH. DV second is a 10-year. Defendant has a history of violence behavior directed towards victim, is a representation of the assistant prosecuting attorney on the case, which is Mr. Pfeiffer filled this out. History of threatening and or harassing behavior. Although Ms. Wanji, your representation is that there's never been a domestic violence charge in this, but this is a DV second, correct? So that DV involves somebody else?
You know, he's been charged. It's the first time he's charged with this kind of crime. And again, there was that recommendation when he was doing the arraignment, because I'm the one who did the arraignment. And like that's why I said that after talking to him and checked some of the court files, I did not see any failure to appear. And he represented to me that there was this lady, they started meeting back in June, and he's the one who called the police. So there has never been a assaultive behavior regarding him.
But so the conviction on September 16th, 2002 is incorrect? The prior conviction? Because it's charged as a second offense, a 1 year. which would mean that in 2002, he was previously convicted of domestic violence.
Yeah, that was the representation to me by my client, Your Honor.
So that was denied? All right. And then he's also has a fourth offender habitual notice that was also denied by your client?
No, he went to prison, Your Honor, and that's why he's saying that there was no reason why he has always come to court when requested to do so. So he has really no history of failure to appear. And I understand that there may be some assaultive behavior, but the courthouse also to understand that he is presumed innocent until proven guilty.
Right. Presumption of innocence is a part of the case, but that can be made, that's usually made in any case. There's a presumption of innocence. I will modify bond at the request. And we also have till March 22nd, but I'll modify bond, but I'll only lower bond concerning this matter because of the criminal history and the assaultive behavior and the fourth offense notice. And this is a GBH and DV second offense. So I'll modify bond to 10,000, 10%.
Thank you, Your Honor.
Thank you, Ms. Wanji. All right, so I modified bond to 10,000, 10%. Anything else for the record in docket 23-02979, Ms. Petrosky?
Nothing for the people, Your Honor.
Ms. Wanji?
Nothing, thank you, Your Honor.
All right, Mr. Thompson, your next date is March 22nd at 9:30 in front of Judge Simmons. That'll be set for prelim on that date. That's all for the record in that file. Thank you, everybody, for your appearance.
Your Honor, can I have a breakout room with my client, please?
Yeah, we can put you in a breakout room with Mr. Thompson.
Thank you, Your Honor.
Thank you. So Ms. Wanji, already done. Watch that skill set. We're gonna start making that a part of your duties. Must be super fast on Zoom. All right, Mr. Goodrich and Mr. Schimpf, we're ready on your case. So we're on the record in docket 23-01924. That's People of the State of Michigan versus Ronnie Elliott. Will the parties please introduce themselves for the record? Mr. Schimpf.
Thomas Schimpf, Special Assistant Attorney General, here on behalf of the people.
Thank you. Mr. Goodrich?
And Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Elliott, who's appearing over Polycom from the jail today.
And sir, you are Ronnie Elliott, is that correct?
Yes, sir. Yes, Your Honor.
All right, you can hear me all right, Mr. Elliott?
Yes, Your Honor.
All right, this is the time set for a probable cause conference in front of Judge Simmons. This is Judge Simmons' case. Mr. Schimpf, how are we proceeding today?
We've had a conversation. I've had a conversation with Mr. Goodrich, and I understand that the defendant is willing to waive the preliminary exam, and they are going to request a change in bail.
All right, so there will be a motion of modification of bond. We'll do, and Mr. Schimpf, that's your understanding. It's a waiver of the preliminary examination, and I'm assuming negotiations are to continue in circuit court.
Yes, Your Honor.
All right, Mr. Goodrich, you heard the statement made by the Attorney General or the Assistant Attorney General. Defendant's going to waive his right to a preliminary examination. Negotiations are to continue, and then you're going to be requesting a modification of bond in this matter. Is that correct?
That is correct, Your Honor.
All right, let's do the prelim first, and then while we do the paperwork, I'll hear the motion for modification on that before I sign it. Okay, sir? May I inquire of your client of his waiver of the preliminary examination?
Yes, Your Honor.
All right. Mr. Elliott, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Luke Goodrich, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, Your Honor.
It is my understanding today, it is your wish to waive your right to a preliminary examination, have this case continue to circuit court where negotiations will be continuing between your attorney and the Assistant Attorney General. Is it your wish today to waive your right to a preliminary examination?
Yes, Your Honor.
All right. Mr. Schimpf, the Assistant Attorney General also waives their right to preliminary examination?
Yes, I do, Your Honor.
All right. I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And before I sign this, I'll introduce the modification of bond. But since everybody's by Zoom, I'll ask, I have the paperwork here. Let me find it. Maybe I can do this by Zoom. Do I have your permission, Mr. Goodrich, to sign the examination waiver on your behalf?
Yes, Your Honor.
And then, Mr. Schimpf, do I have your permission to sign the examination waiver on your behalf?
Yes, you do, Your Honor.
All right. I'm going to indicate the examination has been waived on February 2nd, 2024. Before I sign it, Mr. Goodrich, bond modification motion.
Thank you, Your Honor. Your Honor, with this being a child support case, the state has the law where they start with the 25% of whatever the arrearage is at the time. As a result, the bond was set at $5,227 cash. However, the law does allow the court to find good cause to change that amount. And we would ask the court to change the bond, not to some type of PR bond, but to a $1,500 cash bond, because that's all of the money that Mr. Elliott can put together at the moment. While he's been in jail, he's contacted a friend in Jackson where he resides down in that area. And he has got a temp job lined up where he's planning to go there and start working significant hours right away. The goal in this case is to continue to try to pursue the plea agreement that requires substantial payments along the way. And obviously he's not going to be able to do that if he's forced to stay in jail the entire time. So again, we're not asking for a PR bond. We're just asking that the court reduce the cash bond down to $1,500, Your Honor. Thank you.
Any response, Mr. Schimpf?
No, we'll let it, defendant's motion stand.
All right. So I'm going to modify bond to the $1,500 cash or surety as indicated by counsel. So the bond is modified to $1,500 cash or surety, and I will sign the bind over document. Anything else? So, Mr. Elliott, please keep in contact with your attorney, Mr. Goodrich. I've modified the bond to $1,500 cash or surety, and your time in district court is done. You'll be on to circuit court where negotiations will continue, and you'll get your next date in circuit court from attorney, Mr. Goodrich. All right, sir?
Thank you, Your Honor.
Anything else for the record in 2301924, Mr. Goodrich?
No, Your Honor.
Mr. Schimpf?
No, Your Honor.
All right, thank you. That's all for the record in this file. You're all set, Mr. Elliott. Thank you for your appearance today.
Thank you, Your Honor.
New Year's service.
Sir, from the Eagan County Post, can you identify yourself?
Jaquan Foreman.
All right, Mr. Foreman, you should be in contact with the attorney, Mr. Freeman. Your case has just been left on for prelim next week. All right, sir?
All right.
All right. So if you have any questions, contact Mr. Freeman. But right now, you're set for prelim next week in front of Judge Simmons.
What's the date?
Say it again.
What's the date for the prelim? Sorry.
Oh, the date and time for the prelim, that's hard. What are we doing? February 9th at 9 a.m.
Okay.
All right. That'll be live in front on the 6th floor of City Hall. But you can talk to Mr. Freeman about that. That case has just been left on. Okay, sir?
Okay.
You should be all set. Thank you for your appearance today.
All right.
Sir, on the Ingham County Jail Post, would you please identify yourself?
Alvin Gindel.
All right, so we're on the record in 23-03222. That's People of the State of Michigan versus Aaliyah Billups. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Yang.
Good morning, Your Honor. Joseph Yang on behalf of Ms. Billups, who is president to my right.
And ma'am, you are Aaliyah Billups, is that correct?
Yes.
All right, thank you. This is the time set for a prelim, I believe. Yes. Ms. Wilson, how we proceed?
Thank you, Your Honor. It's my understanding that defense counsel is going to be asking for an adjournment in this matter. There is a co-defendant that was just, I believe, Monday found competent. And I believe it was set for PCC later this month. I am objecting to the adjournment at this point. This case has been on the docket for a bit. The victims have appeared for everything. They're here today. They've appeared even when they didn't need to be here. It's becoming kind of a hardship on them. So I would request that we run this today.
All right, Mr. Yang.
Thank you, Your Honor. It was brought to my attention today that the co-defendant was found competent and ready to proceed. I did look up the dates if I'm not incorrect. PCC is the 9th and prelim is the 16th. I've checked my calendar. That works for me. I don't need any dates changed or anything like that. I'd request an adjournment to marry up the two cases just for efficiency purposes, Your Honor, not only here in district court, but potentially in circuit court as well.
Ms. Wilson, there was a waiver of 21-day rule in November 30th. My request, I understand the nature of your request, but your witnesses would have to come twice then. They'd have to
Assuming-
come on the other prelim and on this prelim.
Assuming that one runs, yes.
Yeah, and so they're prepared to do that, or do they just want to come one more time for the prelim to be set?
Well, I mean, they're here already today, so I guess they're gonna have to appear anyway if we're gonna set this out. So I guess whether or not they're willing to come again is kind of a moot point.
But it's up to them. I mean, they're gonna, they can come today and then come on the 16th. They have to testify both times
Yep.
if the other one goes.
Mhm.
Or they can testify, they've got 2 times regardless, you're
Yeah.
right,
Mhm.
you know? So do they want to testify once or do they want to testify twice? And the other thing is because the 21-day rule was waived, I don't want to put Mr. Yang in a position where he's not prepared to go to prelim. Everybody's got to be prepared to go to prelim. But I understand the nature of of the victim's requesting this because they have come. What I'm most likely to do is to set it on that 16th date and everybody comes and we're gonna get ready for prelim or not that day. But if it doesn't happen that day, then it's either going to be a waiver or a prelim's going to happen. So you can tell your witness, I kind of made the decision.
Okay. Yep.
You could so they're going to testify once and they're going to testify on that second date. So the prelim will be set for, I'll grant the adjournment. The waiver of the 21-day rule has already occurred. And the prelim will be held on the same date as the co-defendant who was just found competent.
Correct, yep.
And that'll be on March 16th. What date? February 16th. All right, so that's not too long an adjournment. So we're talking about a week, 2 weeks. All right. What's that?
9:30.
February 16th at 9:30. We'll set both prelims for that date on February 16th at 9:30. And whatever happens at the probable cause on the other, which you will know because you'll be here.
Right.
But we're most likely to set everything on that day.
My understanding from our hearing on the competency was that the defense attorney was going to try to use this prelim as a determiner of what he was going to do at the PCC.
Yeah,
So
I would give them a heads up that
Yeah.
everything's going on February 16th.
okay, sounds good.
So yeah. So so your witnesses only have to come one more
Okay.
time. Right. All right. So I'm going to grant the adjournment to February 16th at 9:30, Mr. Yang. Ms. Phillips, please keep in contact with Mr. Yang. You'll be set here for February 16th at 9:30. You'll get notice from my court officer. All right, ma'am?
Okay.
All right. Anything else for the record in 23-03-222, Ms. Wilson?
Nothing for the people, Your Honor.
Mr. Yang?
Nothing further, Your Honor.
All right, thank you. We'll see everybody on that February 16th date.
Right, I'll get back on and get a
Yeah.
breakdown.
Yep.
And then I believe we're ready on Jalen Davis, Your Honor.
All right. Mr. Fagelson, how are you?
Well, Judge, how about yourself?
I'm good. All right, so we're on the record in docket 24-00122. It's people of the state of Michigan versus Jalen Davis. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Jalen Davis, who's standing to my left.
And sir, you are Jalen Davis, is that correct?
Yes.
Thank you. This is the time set for a preliminary examination in front of myself today. Mr. Wilson, how you proceed? Ms. Wilson, how will you proceed?
Thank you, Your Honor. The people don't have the necessary witnesses to proceed at this time, so I anticipate a motion to dismiss from the defense.
Yes, Your Honor, we wish to dismiss this case. We are aware that it is without prejudice. The defense stands ready to proceed today, and we'd ask the court dismiss the matter.
All right, thank you. Ms. Wilson, the complaining victim has been subpoenaed and then there's been no contact.
There has been contact, Your Honor, but it's not been cooperative.
Okay. Like that. All right, we're getting the Nolly process or order of dismissal to go forward. Mr. Davis, I'm in position of the order of acquittal or dismissal, commonly referred to as a Nolly process. 24-00122 is the name of this case. Based on your counsel's representation, I'm going to dismiss the case without prejudice, which has been explained to you. It means that people could reissue if they choose to, but for our purposes today, the case is dismissed. All right, sir? With that understanding, I'll sign the Nolly Pros. Anything else for the record in 24-00122, Ms. Wilson?
Nothing for the people, Your Honor.
Mr. Feigelson?
Nothing else on behalf of Mr. Davis, Your
All
Honor.
right, thank you. That's all for the record in that file.
Is there a bond violation scheduled?
I believe it was
I
for
do think there's a
non-payment on
bond, but
tether. I'm assuming that's being nullied as well.
let me. Is that in there?
I know we addressed it briefly at the PCC, but it hadn't been formally submitted to the court.
I don't have a,
I think it was that first one.
I believe Your Honor gave him to today to present proof of his indigent status to JSG, but obviously if it's being dismissed.
Right, you're unable to
I just want to make sure we addressed it.
Thank you. Thank you. I appreciate that. All right, this was also scheduled for bond violation. It's not in a separate file, but it is. But based on the representations of counsel today that they're unable to proceed today, Mr. Feigels, I'm assuming you're requesting a dismissal of the conditional bond violation.
Yes, Your Honor.
Right, the bond violation is dismissed pursuant to the inability of the plaintiff or prosecutor to go forward. It's dismissed without prejudice. Anything else for the record in docket 24-00122, Ms. Wilson?
Nothing for the people. Your
Mr.
Honor.
Fikes?
Nothing on behalf of Mr. Davis.
All right, you're all set, Mr. Davis. Thank you for your participation.
I believe we're ready on Mr. Peden as well, Your Honor.
Mr. Peden. All right, so we're on the record in docket 23-02981. That is People of the State of Michigan versus James Peden. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Fikes.
Good afternoon, Your Honor. Assistant Public Defender Stephen Feigels. Good morning, excuse me. Mr. Peden's present here to my right today, Your Honor.
And sir, you are James Peden, is that correct?
Yes, Your Honor.
Thank you. This is the time set for a preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. The people also lack the necessary witnesses on this matter, so I expect another motion to dismiss from the defense.
The people are unable to proceed today, and the necessary witnesses were subpoenaed. Is that correct, Ms.
Yes,
Wilson?
Your Honor. Yes.
So the
Oh, yes, Your Honor, sorry.
They failed to appear and they were subpoenaed. All right, and then, so you have a motion to dismiss based on the people's inability to proceed, is that correct?
Yes, Your Honor. Mr. Peden is also aware this is without prejudice. They could refile if they choose to.
All right, thank you. So I'm in possession of an order of acquittal or dismissal or nollie pros in docket 23-02981. This is an indication people are unable to proceed based on the subpoenaed witnesses failed to appear. I will sign the nollie pros order of dismissal to that effect. So as indicated by counsel, Mr. Peden, this is dismissed without prejudice, which means the people could reissue if they choose to, but for our purposes today, the case is dismissed. All right, sir?
Yes, sir.
Anything else on the record in 23-02981? Ms. Wilson?
Nothing from the people, Your Honor.
Mr. Feigels?
Nothing for the defense.
All right, thank you.
I got one more question, Your Honor. I was told to turn in my gun license and my gun license was void. Is that no longer void? Or?
Yeah, well, I don't know. That's between you and the administrative agency.
Okay.
So you have an argument now that the case has been dismissed, and you should call them.
Yes, sir.
Because there's no other, but carrying a CPL is a privilege, so they kind of have their own rules.
Yes, sir.
Okay?
Yes, sir.
All right. Thank you for your appearance today.
Thank you.
Hey, James, let me get your copy of this.
Abbott, he's talking about Abbott.
Yeah.
He's here, he's down in Fraser, he's talking mounts.
Oh,
I can go
okay.
find him.
Yeah, that'd be good.
Mr. Plummer, I think your client is on Zoom. Is that right or wrong?
No, which one, Judge?
The one on the, who's,
Oh, Corey Hartwig
That's
was
mine.
originally mine.
Okay.
But Sarah.
Yeah, because I have her.
Well,
location.
Yeah.
all right.
I was gonna say, I do have a client here, but he's sitting in the hallway.
You let me know, but I have you for Mr. Hartwig. It's Miss Donna.
Yes.
Yes, it's Miss Donnelly now because you have.
I have her
another
other case.
Right.
All right.
Yeah, that's no problem.
I
Do you have other
get-
cases?
I
Yeah.
get tired. I'll go find it.
Yeah. That's what Aaron said earlier, so.
Miss Hartwig.
He was on Zoom, he's in jail.
Miss Hart, oh, Miss Hartwig.
Yes.
When's the exam?
What's what?
Time's the ninth.
We'll talk. next
No,
week.
23rd,
Oh, they moved it.
because you have a trial.
Oh, yeah.
Yeah,
So
so
Miss-
it's been moved.
So Miss Donnelly, Miss Hartwig is here.
Yes, I'm ready to
You
proceed.
want to go on that?
Yeah.
And that is Miss Petrosky.
Yes.
All right, so we're on the record in docket 24-00093. That's people of the state of Michigan versus Corey Hartwig. Will the parties please introduce themselves for the record? Ms. Petrosky,
Assistant Prosecutor Paige Petrosky on behalf of the people.
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Corey Hartwig, who is appearing separately by video.
And ma'am, you are Corey Hartwig, is that correct?
Yes, Your Honor.
All right, you can hear me all right, Ms. Hartwig?
Yes.
All right, this is the time set for a probable cause conference. So Judge Simmons' case, Ms. Petrosky, how we proceed?
I would defer to defense.
Ms. Dunn.
Thank you, Your Honor. Ms. Hartwig has a case pending in front of Judge Aquilina. They're waiting for this file to get up there so that we can have a global resolution. So if it's at all possible, I know that the court usually requires these things in person, but I wasn't able to get a hold of Ms. Hartwig today to have her appear. But she is here by video, and I was just hoping if we could waive this up, she would be willing to waive her right to a preliminary exam.
Ms. Hartwig, is that a fair statement? You'd be willing to waive your right to a preliminary examination via Zoom to have this case continue in circuit court for a global resolution on other files? Is that's your attorney's representations? Is that a fair statement?
Yes, Your Honor.
All right. So Ms. Donnelly, may I continue to inquire of her waiver of the prelim?
Yes, Your Honor.
All right. Ms. Hartwig, you understand that you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented by attorney Sarah Donnelly today, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, ma'am?
Absolutely, Your Honor.
It's my understanding it is your wish today to waive your right to a preliminary examination and have this case go on to circuit court where negotiations will continue. Is it your wish to waive your right to a preliminary examination today?
Yes.
And Ms. Petrosky, do the people also waive their right to preliminary examination?
The people also waive their right.
All right. I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And preliminary examinations are to continue in this case. I will provide the circuit court bind over for counsel to sign. And then Ms. Donnelly, you may be requesting that for permission to sign on behalf of your client.
Corey, are you okay with me signing on your behalf?
So I'm in possession of the bind over. This examination was, actually, this is a probable cause conference, isn't it?
Yes.
I'm not gonna check that. I will sign it to that effect on the charge and complaint. So, Ms. Hartwig, your time in district court is done. You'll get your next date from Ms. Donnelly in circuit court where the case will continue. All right, ma'am?
Okay, thank you so much.
All right. Anything else for the record in 24-00093, Ms. Petrosky?
No, Your Honor, thank you.
Ms. Donnelly?
No, Your Honor.
You're all set. Thank you for your appearance today. Thank you for your appearance, Ms. Hartwig. You're all set.
Okay, thank you.
Met with both the individuals in jail, so.
Mr. Goodrich?
Yeah.
So, Mr. Goodrich, which case would you like to go on first?
We could do Mr. Kindle first.
Mr. Kimball. That's it. That's once again you, Ms. Petrosky. Is that correct?
Yes, I believe both of Mr. Goodrich's cases.
All right. It was taken off?
Yeah, Mr. Trevino, we did his PCC virtually,
Okay.
or off the record.
Yep. Mr. Hogue is actually a Judge Ward case.
Oh, okay. Perfect. Mr. Hogue. Perfect. All right, so we're on the record in docket 24-00058. That's people of the state of Michigan versus Alvin Kindle. Will the parties please introduce themselves for the record? Ms. Petrosky.
Thank you, Your Honor. Assistant Prosecutor Paige Petrosky on behalf of the people.
Mr. Goodrich.
Attorney Luke Goodrich from the Public Defender's Office, here to represent Ms. Kindle, who is appearing over Polycom from the jail today.
And sir, you are Alvin Kindle, is that correct?
Yes, sir, I am.
All right, you can hear me all right, Mr. Kindle?
Yes, sir, I can hear you fine, sir.
All right, thank you. This is the time set for a preliminary, for a probable cause conference. Ms. Petrosky, how are we proceeding?
I would defer to defense.
Mr. Goodrich.
Your Honor, at this time, Mr. Kindle would like to leave this matter set for preliminary exam next week.
So leave on for the preliminary examination for February 9th, 2024 at 9:30. That'll be in front of Judge Simmons. So anything else for the record in 24-00058, the prelim is left on for February 9th, 2024 at 9:30, Ms. Petrosky.
Nothing from the people, Your Honor.
Mr. Goodrich, anything else on the record for that file?
Nothing more on the record, Your Honor. Thank you.
All right, Mr. Kindle, you're all set. You'll be in front of Judge Simmons on February 9th at 9:30. Thank you for your appearance today.
Thank you, sir.
And are we ready on the Ward case?
Mr. Hogue.
Hogue. Christopher Hogue. Is that, so Mr. Goodrich, that's 4-3 and 5-1?
Yeah, he has two files.
Okay. Let's treat those separately. Let's go on the 4-3 file first. So we're on the record in docket 24-00143, People's State of Michigan versus Christopher Hogue. Will the parties please introduce themselves for the record? Is that Mr. Need?
Yes, Your Honor. Thank you. George Innit on behalf of the people.
And then Mr. Goodrich.
Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Hogue today, Your Honor.
All right, this is the time set for a probable cause conference. This is set in front of Judge Ward. And sir, you are Christopher Hogue, is that correct?
Yes, sir.
All right, you can hear me all right, Mr. Hogue?
Yes, sir.
All right, this is the time set for a probable cause conference. Mr. Need, how are we proceeding?
You know, I would defer to the defense.
Mr. Goodrich.
Thank you, Your Honor. Your Honor, Mr. Hogue has been in the process of attempting to hire Toby White as his attorney. Obviously, that has not happened as of today, but I have confirmed with Mr. White that they are working on that with his family. I know Mr. White has a murder trial that's coming up I know in February. He asked me to have Mr. Hogue waive his 21 days today and ask that the preliminary exam be moved out an additional month, probably into mid-March.
All right. All right, Mr. Need, is that your understanding? Or is that the first you've heard of that?
No, I was under the impression that it was gonna be a new defense attorney. I have no objection to what defense's request at this time.
All right. Mr. Goodrich may inquire of Mr. Hoag on this file of his waiver of the 21-day rule in order to retain counsel.
Yes, Your Honor.
Mr. Hoag, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. For our purposes today, at this probable cause conference, you're represented by Attorney Luke Goodrich. It's my understanding you are seeking to retain Attorney Toby White in the matter, and therefore you're requesting a waiver of the 21-day rule, which is to have your prelim within 21 days so you can retain Mr. White so he can zealously represent you in your defense. Is that my understanding today, sir?
Yes, sir.
All right. So you're in agreement with me that it is your wish to waive your right to a prelim within 21 days. You won't be waiving your right in general, just to have your prelim within that 21-day period. Is that correct, sir?
That's just to have it go up to next month, yes.
Okay. So you are waiving your right to a prelim today.
I'm not waiving
Within
it.
21 days.
I'm sorry,
Yes.
within 21 days.
Yes.
Okay. I find the waiver of the prelim within 21 days. So the 21-day rule waiver to be knowing, voluntarily, and accurately made. And what was the time frame for Mr. White that he gave to you? Sometime in March?
Yes. Probably at least a week into March, if not, kind of mid-March area.
March 14th at 8:30 on this file. We'll set it for prelim. And Judge Ward will wait for Mr. White's appearance on the matter. But we'll set 24-00143 for March 14th at 8:30. Anything else for the record on this file, Mr. Anid?
No, Your Honor, thank you.
Mr. Goodrich?
No, Your Honor.
All right, and then we have another file for Mr. Hoag, and let's go ahead and get everybody's appearance. I don't know what I do with that file. Let's see. File. Let me find that other file and we'll be on the record in a second. So we're on the record in docket 24-00151. That is people of the state of Michigan versus Christopher Hoag. Will the parties please introduce themselves for the record? Mr. Need.
George and on behalf of people, Your Honor, thank you.
Mr. Goodrich.
And Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Hoag, who's appearing over Polycon from the jail today.
And once again, once again, you are Christopher Hoag, sir?
Yes, sir.
All right. This is time set for a preliminary examination or probable cause conference in the matter. And Mr. Need, we previously had a file concerning Mr. Hoag. Did you want to defer to Mr. Goodrich concerning the file? Mr. Goodrich, how are we proceeding on this file today?
Your Honor, we would like to proceed exactly like we did in the previous file. We would ask that he waive his 21 days and have the preliminary exam moved to that same date on March 14th at 8:30.
Perfect. Right, it's my understanding, Mr. Hoag, it is your wish today to waive your right to a prelim within the 21-day period today in order to retain Mr. White for counsel. Is that a fair statement, sir?
Yes, sir.
It is a preliminary examination is a probable cause conference in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. Mr. Goodrich is here for purposes of the probable cause conference to represent you. It's my understanding you wish to waive your right to a prelim within that 21-day period to retain Mr. White, who will represent you in this matter. Is that a fair statement?
Yes, sir.
So it's your wish today to waive your right to a prelim within that 21-day period and have this adjourned to the March 14th date on your other file.
Yes, sir.
All right. People also waive their right to a prelim within 21 days.
That is correct, Your Honor.
All right. So I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And I will set this for prelim on March 14th at 8:30. Anything else for the record in 24-00151, Mr. Anid?
No, Your Honor, thank you.
Mr. Goodrich?
No, Your Honor, thank you.
All right, Mr. Hoag, both files are set for March 14th at 8:30. You'll be in front of Judge Ward on that date. Thank you for your appearance today.
You.
Your Honor, so we have two individuals who were set for prelim today who are downstairs. I believe neither of them are running today. I don't know what order you want to address them in. I know it's kind of a hassle to get them up here, so I don't know if you want to leave them until the end of the PCCs or bring them up now.
But who are the attorneys?
Mr. Abbott and Mr. Silverthorne.
Yeah, so if counsel's going to talk to their client, we don't have to bring them up.
I can go down and tell them if it's going to be dismissed.
Okay, and same with you, Mr.
I've
Silverthorne?
gone over with my client what a waiver was and how it would proceed, so.
We got to waive the
He
21
can
days.
stay down there and do it on.
They don't.
Right, let's bring up Mr. Silverthorne, so we'll waive
So
on the
Mr.
record.
Walker.
Okay.
Jamal
Yeah.
Walker. Yeah.
So Mr. Walker, we can bring up, and then yours is the dismissal, Mr. Abbott,
Yeah.
is that correct?
Higby, yeah, we don't need to bring Mr. Higby up.
All right,
Okay.
that's Mr. Higby.
And I'm ready to go on that one. Of the
All right, and then Mr. Bargain Cost is here, Mr. Austin. All right, so let's go on Mr. Higby. All right, so we're on the record in docket 24-00003. That's people of the state of Michigan versus Robert Higby. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Good morning, Your Honor. John Abbott with the Public Defender's Office representing Robert Higby. He's downstairs in lockup right now.
Right. This is the time set, and we had a previous conversation on the record that Mr. Higby is in lockup at this time. So we're waiving his appearance for this preliminary examination.
Correct, Your Honor.
For this prelim purposes. Ms. Wilson, how are we proceeding today?
Thank you, Your Honor. The people lack the necessary witnesses to proceed to a preliminary exam on this matter, so I anticipate a motion to dismiss from the defense.
Mr. Abbott.
Thank you, Your Honor. I move to dismiss with prejudice. This is a reissue of 22-2992 FY, which was dismissed earlier for the same reasons. No witnesses.
Proceed.
Your Honor, I would object to the dismissal with prejudice. I don't think there's a legal grounds at this point for dismissal with prejudice. I will state for the record that I don't believe it's our intention to reissue at this time, but I would object to the dismissal with prejudice.
The witnesses have been subpoenaed.
They have been
And
subpoenaed.
Any contact with them?
Contact uncooperative again. It's the theme of the day.
All right. So let me see the nollie process of dismissal in this case. I'm not sure. Makes you check the box. Seems unreasonable, but it'll make you check the box. At least it's working. All right, there's a request for dismissal with prejudice. It's my understanding that dismissal in a criminal case is without prejudice generally. This does seem to be the second aspect of this case with the victims failed to appear. But I don't know if that overrides the rule that a dismissal has to be with prejudice. The people, of course, have indicated that it is not their intent to proceed on the case based on, I mean, I don't know what's going to change. So at this time, I understand the request for dismissal with prejudice. I'm gonna dismiss this case without prejudice. It could be reissued if you choose to. My understanding is it probably won't be, but I understand that the request. I'm indicating that the case is dismissed without prejudice today. Anything else for the record in 240003, Miss Wilson?
I recognize that this case has been dismissed, but just for the record, I believe Mr. Higbee is has a bond order on another file. So I understand that's not really relevant to this case, but for purposes of whether or not he's being released, I don't believe I think he has another hold, is my.
Right. Mr. Abbott, he might have something on another file, but this one's dismissed.
I understand, Your Honor. He is held by the circuit court.
Okay. All right. Anything else on the file, Mr. Abbott?
No, thank you.
All right. Thank you. That's all for the record in that file. Thank you, everybody, for your appearance.
Thank you.
Yeah, because he motioned for dismissal with prejudice, and I motioned. Darian Ray. Oh, thank you.
I believe I'm ready on that one.
All right. Okay. So.
Well, we don't have Mr. Walker yet.
Yeah, we don't have Mr. Walker yet. So, Mr. Silverthorne, we'll call your case as soon as your client comes out.
I'll be over there until I see him come. Thank you, guys.
All right, thank you, Mr. Silverthorne. Is there a Mr. Ray? You can come up here. All right, so we're on the record docket 24000104. It's people of the state of Michigan versus Darian Ray. Will the parties please introduce themselves for the record, Ms. Wilson?
Abigail Wilson for the people.
And sir, you are Darian Ray, is that correct? All right, thank you. This is the time set for preliminary examination day. It's my understanding, Mr. Ray, you were at the probable cause conference, you indicated you were seeking an attorney. You don't have an attorney today, is that correct?
Right.
Is it your wish today to continue to seek for an attorney? Okay. Have you reapplied to the court to the public defender is only going to take you if your financial situations change? Have you reapplied to the public defender, or is that a no-go and you're simply retaining your own attorney at this time?
Yes, I know.
All right. Well, I find good cause to adjourn based on Mr. Ray does not have a lawyer today and he's seeking a lawyer. Okay.
The people have no objection.
Okay. So we want you to have a lawyer, and we want to make sure that you don't waive any rights without a lawyer, anything along those lines. But everything's in person now. Okay. So probable cause, we're going to do everything in person so that we have here, just to keep it on the record, just to make sure that you're represented and that there's a lawyer present. Okay, so I find good cause to adjourn. Mr. Ray's indicated that he is still seeking counsel. And I know a week is not a long time to do that. I'm going to adjourn for a good cause. So there's no waiver of 21-day rule. There's no waiver of rights without a lawyer. But I can't stress to you how important it is. This is a 5-year felony. So you want to get somebody to advocate on your behalf, okay? You want to get a lawyer and make sure you have a lawyer. So retain somebody before our next, because we're just going to set it for prelim, because the probable cause conference is done. And then we'll let Ms. Wilson negotiate from the prosecutor's office with whoever you retain, okay, sir?
Okay.
All right, so adjournment, probably post 2 weeks.
And once an attorney is retained, if Mr. Ryan wants to have him reach out to me immediately, I can relay
All
our
right.
number.
So make sure Ms. Wilson is the assistant prosecutor on the case, all right? 3 weeks. March 22nd.
I'm sorry, February.
February 22nd at 8:30 is your notice for prelim. So you should get notice. All right. Ms. Wilson, I'm going to grab you.
Okay.
If you could give Mr. Ray notice from the printer, that should be just printed. And that will provide notice, and you can give that to any attorney you retain, okay? Now, if you come on February 22nd and you don't have a lawyer, then we might we might be requesting that I'm just going to assume you're representing yourself, all right? At that time, and at that time, we're going to go forward, all right? So my advice to you is to get a lawyer as soon as possible, okay? Anything else for the record in 2400104, Ms. Wilson?
Not from the people owner.
All right, Mr. DeRay, you're all set. You have your notice. Thank you for your. Do you want to go on BarQuest? He's here. All right, Mr. BarQuest, we'll call your case. So we're on the record in docket 2400145. That is People of the State of Michigan versus Trevor Barganquist. Will the parties please introduce themselves for the record? Mr. Anid.
Thank you, Your Honor. George Aden on behalf of the people.
And thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Barganquist, who is appearing with us today on Zoom.
And sir, you are Trevor Barganquist, is that correct? Oh, I can't hear you. So you might want to talk into your mic because we have you on audio.
Yes, I'm Trevor Barganquist.
Okay, thank you. This is the time set, and you can hear me all right, Mr. Barganquist?
Yes, I can.
All right. This is the time set for a probable cause conference. Mr. Need, how will we proceed?
Thank you, Your Honor. It is my understanding that we are leaving this set for preliminary examination at this time.
So we'll leave on for preliminary examination on February 9th, 2024 at 9:30. Mr. Barganquist, that'll be live in front of Judge Ward at 9:30 on February 9th. All right, sir?
Yes.
And I'm talking to the mic because I still can't hear you.
Yes.
All right, thank you. Anything else for the record, Mr. Austin?
Just a note to make a record, Your Honor. This case was initially assigned to someone else in my office. I was reassigned on that yesterday, but I do now have good contact from Mr. Barganquist. I was able to direct him to the proper Zoom court today, and we have the discovery. It's rather short in nature, so I think we'll have adequate time for me to discuss with Mr. Barganquist between now and next week as to how to proceed.
All right. So Mr. Barganquist, please keep in contact with your attorney, Mr. Austin, on the case. It's been set for February 9th at 9:30. Anything else for the record of Mr. Need?
No, Your Honor, thank you.
All right, thank you for your appearance today. We're all set. Judge Ward will see you next week, Mr. Barganquist, okay?
Okay.
You're all set, sir.
Have a good day.
Did we do Ashley Giles? I'm asking you. That's Judge Ward. Did we do Miss Giles?
I don't represent.
I don't think she's represented.
No, she's denying CAA.
It's not my docket, Your Honor.
It's not on your docket.
What was the name again?
Ashley Lynn Giles, Giles, set for 10.
Attorney General.
Attorney General, okay. All right, we'll wait for their appearance.
Can anybody hear me? Can anybody hear me?
Sir, from the Ingham County Jail, could you please identify yourself?
I'm Kenneth Reed.
Timothy Reed.
Kenneth Reed.
Yeah, we love this.
What's that?
You're at the class.
Is that Mr. Feigelson? On your docket, Mr. Need.
That is Mr. Yes, let me give him a call real quick.
All right.
Other than that, it's my understanding that Mr. Mauer and Mr. Williams intend to run their exams today. So we're just waiting on those ones.
And that is Mr. Vashon Williams.
Correct, yes.
And then we're bringing up Mr. Silverthorne's client.
Correct.
We already got on Mr. Walker.
That's Mr. Silverthorne.
Oh, they're both.
Yeah, both of he has 2 files, yeah.
Two files.
And we're doing the same thing on both of them. Or we're asking for to do the same thing on both of them.
So we're good on that. On this, on Judge Ward's, we have Mr. Reed. How about Miss Wheeler? That's Mr. Etheridge, is that correct?
She's also in custody.
Yes.
Mr. Feigelson said he wants to leave the separate preliminary exam. Does he have to join on Zoom?
No, I can leave it on as long as he tells his client that.
He said he spoke with him the other day.
So Mr. Reed's here. Does Mr. Feigelson want to be here?
He's asking the court if he has to.
Have him come. So let's put it on the record just to protect him.
He'll probably have to, I'm sorry, he'll probably have to join by Zoom. I know.
All right. That either or you can step in.
I'll step in.
Yeah.
I don't care.
Yeah.
Why not?
So
I can step in for.
yeah.
I'm here anyway.
Yeah.
Came down for something with Steve and then he was.
But
thinking that was again.
that'll make it easy. We're just leaving it on. But we should get Mr. Anid then back,
I'll go get him.
or else we'll have people stepping in all over the place.
Yeah, I'll go get him.
Yes, sir. I just informed him.
All right, so we're on the record in docket.
Sorry, Hannah.
Oh, I'm trying to find where I am.
Mr. Reed.
Mr. Reed. We're on the docket in docket 23-03429. That is People of the State of Michigan versus Kenneth Reed. Will the parties please introduce themselves for the record? Mr. Anid.
Good morning, Honor. George Annette on behalf of the people.
And good morning, Your Honor, Assistant Public Defender Aaron Schroeder on behalf of Mr. Reed, standing in for his assigned counsel, Steve Feigelson.
And sir, you are Kenneth Reed, is that correct?
Yes, I am.
All right, you can hear me all right, Mr. Reed?
Yes, I can.
All right, this is the time set for a probable cause conference. Mr. Need, how are we proceeding?
Thank you. I've spoken with Steve yesterday and this morning. We intend to leave this preliminary examination at this time.
And that's your understanding, Ms. Schroeder?
It is, Your Honor, and I've confirmed that by notes that I've reviewed just now from Mr. Feigelson.
All right. All right, this preliminary examination will be left on for February 9th, 2024 at 9:30 in front of Judge Ward. So Mr. Reed, you will be in front of Judge Ward next week on this preliminary examination. Anything else for the record in docket 23-03429, Mr. Anid?
No, Your Honor, thank you.
Ms. Schroeder?
No, Your Honor, thank you.
All right, Mr. Reed, you're all set.
Can I say something, please?
You can, but you shouldn't say anything about the facts of the
I'm
case,
not gonna
only
say
the
anything about
process.
the case.
All right.
I'm not gonna say anything about the case. I mean, I just, well, I was out on PR bond. I was trying to see, can I get it back out on the PR bond? Because it was just a misunderstanding that I got my court dates mixed up.
Oh.
Okay. Well, I have this on a PR bond right now. So 5,000 PR. And then there must have been a bench warrant. There must have been a bench warrant issued for you, and that's why you were taken off the PR bond. Okay. I would discuss this with Mr. I would discuss this with
I got my days mixed up. That's all that was.
You should discuss this with Mr. Feigelson because I'm not going to override Judge Ward's remand. Okay.
I mean, I did discuss it with my lawyer. He said he was gonna bring it up today in court, but I see he's not here.
Like he's not, and regardless, even if he brought it up, you're gonna be in front of prelim and in front of Judge Ward. But she remanded you, and I'm not gonna override her remand for fail to appear.
Yeah. May I, Your Honor?
You may.
Mr. Reed, I understand, I can appreciate your frustration. However, as the judge stated, your judge of record, Judge Ward, is out this week. And she is the one who has set you at a remand. So at this point, the court's saying they're not going to override that because they are not your judge of record. So at this point, unfortunately, you're going to be staying.
This can be modified or brought up in front of Judge Ward, either date of prelim and before, but I'm not going to modify her bond. So you should be all set, Mr. Reed. Thank you for your appearance today.
So when this court date is when?
February 9th.
Okay.
Thank you, Ms. Schroeder.
Do you have still Devin Frazier?
Zero 3-443. That's the people of the state of Michigan versus Jamone Walker. The parties please introduce themselves for the record. Ms. Wilson.
Abigail Wilson for the people.
Good morning, I'm Dwayne Silverthorne from the Office of Public Defender on behalf of Jamone Walker, who is sitting to my right at council table.
And sir, you are Jamone Walker, is that correct?
Yes, I am.
Thank you. This is the time set for a preliminary examination. Ms. Wilson, how we proceed?
Thank you, Your Honor. It's my understanding that defense counsel and the people both will be requesting an adjournment on this matter. There was some extensive discovery that was just submitted to both of us on Wednesday. It's my understanding that the defense is still waiting to get part of that discovery as well. So for those reasons and a host of other reasons that are kind of going on behind the scenes as well, we're requesting a brief adjournment.
Okay, and so so Mr. Silverthorne, is that a correct statement? And
Yes.
is Mr. Walker going to waive his 21-day rule?
Yes, I did explain to Mr. Walker that there'd be a waiver of the statutory timeline, is the way I had expressed it, which amounts to an adjournment, I understand, but it's a little more specific. And it is stated correctly. I just, the day or so ago, after my last visit out to the jail with Mr. Walker, received a 44-page CAD dispatch notes and call log, along with a 12-page phone witness interference report that I had just gotten. These are very serious charges. There also will be some oral, I should be able to receive some actual phone calls as opposed to just narrative reports, all of which I need to go over with Mr. Walker before this. And we also understand that probably if we were going to begin a prelim today, we would only start it.
Right.
We wouldn't continue it. So for judicial efficiency, since we're coming back anyway, let's just waive the timeline, have the prelim, but have it a little bit later.
All right. And then we'll set a time that, because I know you've got some trials coming up or that you're busy. But may I inquire your client of his waiver of the 21-day rule?
Please, Your Honor.
Mr. Walker, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. Preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented by Attorney Dwayne Silverthorne today, and he would be present to cross-examine any witnesses, contest any charges brought against you by the people. Do you understand that, sir?
Yes.
Is it your wish today to waive your right to a prelim within that 21-day period? So your defense counsel, A, can get more discovery and can do more negotiations in regards to both these files, but we're only talking about 23-03-443. Is it your wish to waive your right to a prelim within that 21-day period? You would not be waiving your right to a prelim in general, just within the 21-day period.
Yes.
Do the people also waive their right to a prelim within the 21-day period?
We do, Your Honor. Yes, unconditionally.
Okay, I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And we will reset this prelim at, how many weeks out do you think, are you thinking?
2.
And then
Yes.
2 to 3?
Yeah.
2 to 3 at most.
February 22nd.
Okay, we'll set it for February 22nd at 8:30. So on file 23-03-443, the 21-day rule has been waived, and we've set this prelim for February 22nd at 8:30. Anything else for the record in docket 23-03-443, Ms. Wilson?
Nothing for the people, Your Honor.
Mr. Silverthorne?
Nothing from the defendant, Your Honor.
All right, that's all for the record on that file. And then we'll call to the record docket 23-03-607. It's people of the state of Michigan versus Jamone Walker. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Silverthorne.
Dwayne Silverthorne from the Office of Public Defender on behalf of Jamone Walker, who again is standing to my right at council table.
And sir, once again, you are Jamone Walker, is that correct?
Yes.
All right, this is time set for a preliminary examination or probable cause conference set for prelim today. I'm losing track. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. Similarly with the other file that we just concluded with Mr. Walker, there is additional evidence that is related to this file as well that, again, Mr. Silverthorne needs time to go through with this client. So we would be requesting an adjournment and a waiver of the 21 days.
Mr. Silverthorne.
I would agree. I would add that this case, as with the case that immediately preceded it on the record, involves the same alleged victim, and the CAD dispatch notes and call log and phone witness interference reports actually relate to this case as well. So for the same reasons as placed on the record earlier, just moments ago, we would ask that this case also be moved out.
All right, thank you. Mr. Silverthorne, may I inquire of your client of the waiver on 23-03-607?
Yes, Your Honor.
All right, Mr. Walker, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which people would have to prove by probable cause evidence the identity of the person who committed the crime and that a crime was committed on this file. You, of course, are represented by Attorney Dwayne Silverthorne. He would be present at the prelim to contest any charges or cross-examine any witness brought against you by the people of the state of Michigan. Is it your wish today to waive your right to a prelim only within that 21-day period? You wouldn't be waiving your right to a prelim in general in order for discovery, so Mr. Silverthorne can get all the information he needs so he can zealously represent you in your defense. Is it your wish today to waive your right to a preliminary examination only within that 21-day period?
Yes, Your Honor.
And Ms. Wilson, you also waive your right to a prelim.
Correct, Your Honor. The people waive
Within
the right to
21
21
days.
days. Yep.
All right. I find the waiver of the 21-day rule to be knowing, voluntarily, accurately made based on discovery and to continued negotiations. And we will set the prelim for the same date, which would be it would be February 22nd at 8:30 in front of myself. Anything else for the record in 23-03-607? Ms. Wilson.
Nothing from the people, Your Honor.
Mr. Silverthorne.
Nothing from the defendant, Your
All
Honor.
right, Mr. Walker, you're all set. Thank you for your appearance today.
Your Honor, on Fashawn Williams, we have a witness present here today for the prelim. She's having some blood pressure issues and would like to leave soon. So in speaking with Mr. Goodrich, I know that the court has a pretty packed docket today.
Not so much anymore.
Okay, so I'm wondering if maybe we can go ahead on that case now.
Yeah, I have the AG here. Let me move that AG case.
Okay,
And then I think we can start your pre.
okay. Yeah.
So that is Ashley Giles. Let's go ahead. All right, so Mr. Etheridge, you're here on Miss Giles' case, is that correct? Oh, they haven't brought her over yet, have they?
No, it's Miss Willer, Your Honor. She is in the breakout room. I have talked to her. She is prepared to enter a plea at this time.
All right, let's bring her out of the breakout room. Miss Wheeler. All right. And then Mr. Hayes, you're here from the Attorney General, is that correct?
That's correct, Your Honor. Here on Ashley
All right.
Giles. I'm not sure who her attorney is.
Oh, hold on. Now I'm confused. All right, Mr. Hayes, let's call your case on the iPhone. On the iPhone, are you Miss Giles?
Yes, I am.
All right. All right, so we're on the record in docket 23-02255. That's people of the state of Michigan versus Ashley Giles. Will the parties please introduce themselves for the record? Mr. Hayes.
Good morning, Your Honor. Robert Hayes, Assistant Attorney General, here for the people, P69006.
Ma'am, you are Ashley Giles, is this correct?
Yes, sir, I am.
And ma'am, you are not represented by counsel today, is that correct?
Yes, it is. I asked for counsel and they said that I couldn't get one. I'm a single parent of 4 kids. I don't have money to get counsel.
So you were denied court-appointed counsel for some reason. Do you plan to reapply because of financial situations changed with the public defender's office?
Yes.
All right. Mr. Hayes, I'm assuming we're just leaving this on for this, for prelim at this time?
Your Honor, I'd ask that it be set for another PCC at this point, I guess, without Ms. Giles having an attorney. We have the co-defendants scheduled for March 8th for prelim exam before Judge Ward, and I think it makes sense for these all to run together. I'm not sure if she's going to be willing to waive her 21 days without having counsel present and advising her, or if we just need another prelim maybe next week or PCC next week.
Well, I'm going to leave that to Judge Ward to decide. I'm going to leave it on for prelim. Ms. Giles, you should get representation, okay? Either you need to go back to the public defender's office and reapply, or you need to retain your counsel. These are fairly serious allegations. The count 2 is up to 20 years. So what I'm going to do is Judge Ward knows her docket better. What Mr. Hayes says makes sense, that you should be put in with the rest of the defendants so that the preliminary examination is all done at once. But you may need to waive some rights in this matter, and you should do that at your prelim. So Miss Giles, I'm going to leave your prelim set in front of Judge Ward for February 9th, 2024 at 9:30. I'm going to indicate that I've expressed that you should reapply to the public defender's office. Or seek retained counsel, but you have to do so fast since your prelim is set for February 9th at 9:30 tomorrow, okay? It'll be set next week, February 9th at Friday at 9:30. You understand that, ma'am?
I understand that I need to get a counsel, but I don't have money to retain a counsel. I paid
But you need to, then you need
$1,500.
to go to the public, ma'am, then you need to go back to the public defender and indicate you had a change in your financial status, or you'll be representing yourself on that Friday.
Okay.
All right. And I don't think that's something you want to do facing a 20-year felony.
Okay.
So I would go today and reapply to the public defender's office and share with them your change in financial circumstances. You're set for prelim on February 9th. I'm going to indicate that prelim should be live in person for you, ma'am. You should come live to the 6th floor. So you should be there for Judge Ward on the 6th floor. Mr. Hayes, that's a prelim, so it's an adversarial setting. You probably should be there also. And if anything, maybe you can talk to Miss Giles' new attorney if she has one present at that time. I don't know if she will or not, but she should have one.
Absolutely.
All right. All right. So I've set this for prelim, left on for prelim on February 9th, 2024 at 9:30. Ms. Giles, you should reapply to the public defender's office this afternoon, indicating you've had a change in financial circumstances, but you're set for February 9th at 9:30. All right, ma'am?
Okay.
All right. Anything else for the record in 230-2255, Mr. Hayes?
No, thank you, Your Honor.
All right. Thank you. Ms. Giles, you'll be in front of Judge Ward on February 9th next week. Thank you for your appearance today. And then Mr. Etheridge, we can go on Miss Wheeler, and then we're set to start our prelim. So we're on the record in docket 2400150. That's people of the state of Michigan versus Amanda Wheeler. Will the parties please introduce themselves for the record? Mr. Need.
Thank you, Your Honor. Good morning. George Anita on behalf of the people.
Mr.
Good morning.
Etheridge.
Good morning, Your Honor. Attorney Derek Etheridge, also the public defender on behalf of Miss Wheeler. I'm appearing by video. Miss Wheeler is appearing by Polycom from Bingham County Jail.
Thank you. And ma'am, you are Amanda Wheeler, is that correct?
Yes, that is correct, sir.
Okay, and you can hear me all right, Miss Wheeler?
Yes, I can.
All right. This is the time set for a probable cause conference in front of Judge Ward. Mr. Need, how are we proceeding?
Your Honor, it is my understanding there is a plea that we reached today. Count 1 will be amended. It was a motor vehicle unlawful driving away. It'll be amended to stolen property, receiving, concealing 200 or more, but less than $1,000. The MCL for that.
Hold on just a second. So that would be, Judge Ward amends it. I will add a count 3 of that, okay?
Okay.
So that'll be a count 3. Since it's not on a ticket, I'll add a count 3 of RNC. Is that the 1 year?
Yes, Your Honor.
200 to 1,000?
Yes, Your Honor.
Okay. And what's the PAC code for that?
750.53548.
And that is 1 year and or what's the cost?
$2,000.
$2,000. With a plea to count 3. What are we doing with count? What are we?
Count 1 and count 2 will be dismissed. And I would like to inquire with the defense if $140 will be stipulated to today.
Yes, yes, Your Honor. A restitution of $140. I did discuss that with Miss Wheeler, and she stipulates to that amount at this time.
$142.
$140.
$140.
Yeah, Your Honor.
Okay. So the request is an added count 3 of RNC 200 to 1,000, receiving and concealing 750 under 750.534A. So 1 year and or $2,000 upon successfully plea and sentence to count 3, counts 1 and 2 are to be dismissed. Is that correct?
Correct, Your Honor.
All right. And then there's stipulation that restitution will be $140. Is that your understanding of the plea agreement, Mr. Etheridge?
Your Honor, there was an agreement of no further upfront jail time, and there's no objection to PR bond with the following conditions to be added. She is attempting to get into Bear River. So one of the conditions would be to get an updated mental health evaluation, complete an updated intake with Bear River, and if accepted, she is to go to Bear River for treatment. She does not object to being sentenced by Judge Ward in the future rather than this court who has taken the plea, and that she would waive her right to be in person for sentencing and would, if she is in Bear River, would ask that court to allow her to be sentenced by video from Bear River.
All right. So it would be a PR bond in order for, now, is that bond only to have her attend Bear River for treatment purposes? Or is that bond a PR bond in general?
I would prefer it to be for Bear River.
The problem, Your Honor, is we're asking that she be allowed released on PR bond, at a minimum, be released to go to Bear River, but
Right.
she needs to get out to try to get the evaluation, and she's been trying. I understand, to get it at the jail and haven't been able to, but to do the things Bear River wants her to do to get admitted. And I talked to Bear River, and these are the things they told me she had to do. All right, and that's my understanding. I just, if that she will be out. So Mr. Need, if that is part of you're going to PR bond her to rehab, but she's PR bonded, so she's out. Whether she goes to rehab is up to her, but that's the request that's being made.
I'll have no objection to that, Your Honor.
Okay. All right. All right. So with that understanding, the rehab is a part of negotiations, but she's to be PR bonded on this file as part of the negotiations. Is that correct, Mr. Etheridge?
Oh, yes, Your Honor.
Okay. All right. May I inquire of your client of their misdemeanor advice of right, sir?
Yes, Your Honor.
All right. Ms. Wheeler, you understand you have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have any witnesses appear against you, to appear at trial, to question any witnesses brought against you. You are represented today by lawyer Derek Etheridge, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. You have the right to have the court-ordered witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than when been stated on the record, or threats that it was not your choice to plead guilty. You'd be also giving up the right to appeal any issues from trial, because you won't be having a trial today. You'll be pleading guilty instead. Is it my understanding today you wish to waive your misdemeanor rights and plead guilty to count 1 in this complaint?
Yes, I agree.
Okay.
You got it. Count 1 or count 3? I think so.
Oh, count 3. It would be it'd be an added count 3, ma'am. Do you agree that you'd be pleading guilty to an added count 3?
Yes, I agree.
Okay. I'm gonna have you waive your right. I'm gonna have you raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
I'm going to bring your attention back to January 19, 2024 at the offense location of 1826 South Cedar Street in the city of Lansing, Ingham County. Were you present on January 19, 2024 at 1826 South Cedar Street in the city of Lansing, Ingham County?
Yes.
Yeah, Your Honor, she'll lay the factual basis for count 1, Your Honor.
Thank you. And at that time, were you driving or in possession of a Chevrolet Cruze vehicle?
Yes.
Okay. And did you take that vehicle willfully and without authority from the owner of that vehicle, Robert Williams.
Yes.
And he did not give you permission to drive that vehicle. Is that correct?
Correct.
All right. Anything towards a factual basis for count 3, which is the 1 year, Mr. Need.
No, Your Honor, people are satisfied.
Mr. Etheridge.
No, Your Honor, thank you.
Yeah, I find the factual basis to be knowing, voluntarily, and accurately made. So counts 1 and 2 will be dismissed upon successful sentencing on count 3 pursuant to the plea agreement. There is a Killebrew of no upfront jail, and there's a PR bond. So the defendant is to be PR bonded, but must, if accepted to Bear River, must meet with any of their requirements.
Yes, sir.
Including attending Bear River.
Yes, sir.
And Your Honor, in order to be accepted there, she has to get the updated mental health evaluation and an updated intake form.
Right. So you'll need an updated mental health.
So when I make sure, I think I can call an access number to CMH to get an evaluation done.
Yeah, I'm going to refer you to probation because you're going to be PR bonded, but you still have to be sentenced and you still have to go to probation. So I'm going to refer you to probation. After you're let go, you should report to probation within the next 48 hours. All right, ma'am?
Yes, sir.
Okay.
Where's that located? Will it show me on the sheet?
It's 5th floor of City Hall, Lansing.
Thank you. I appreciate it.
So you're 1, and we'll set the sentencing date for
April 5th at 8:30.
April 5th at 8:30. And then they'll let us know about Bear River and, but you have to get a mental health evaluation. And what was the other thing, Mr. Etheridge?
She has to complete an updated intake form. She has done one in the past, but they need to update it after the mental health evaluation. That has to be done first.
All right, so you'll have to complete an updated intake form for Bear River.
Yes, sir.
All right.
What's the amount of PR bond?
The PR bond is PR 1,000. So it's PR bond at 1,000. Your next date will be sentencing date for April 5th at 8:30.
Okay.
What's our last address? Was that Norman Street address still a good address for
Yes,
notification?
that's still gonna address 560 Norman Street.
All right. Make sure to go and talk to probation so they know the plan here. And the plan is to get you into Bear River. Okay, ma'am?
Okay, yes, sir. What was the court date?
I have a lot of questions for you. Go ahead.
On my paper, it says I have a court date on February 13th. So disregard that court date.
Mr. Etheridge, is that on this file or a separate file?
Well, she has the preliminary schedule next week. I think she may be wrong with the date. I don't know
All
the
right,
February 13th date.
This would take care of the February 9th date for prelim. So you do not.
Okay, thank you.
Yeah.
Yes, that's all.
So you're all set on your prelim. Make sure and refer to probation, and your sentencing date on this matter would be April 5th. All right, ma'am?
Okay, thank you.
Anything else for the record in 2400150, Mr. Need?
Would the court like me to fill out restitution form?
Yes. Phil, you have a red restitution form?
Thank you.
And that's for the $140 stipulated to. Yeah, I think probation would want that. Okay. Anything else, Mr. Etheridge?
No, Your Honor, thank you.
You're all set, Ms. Wheeler. Thank you for your appearance. I will see you again on April 5th. All right, ma'am?
Thank you, sir.
All right.
What time does the probation place close today?
Probably 4 o'clock. But that is on the 5th floor. That's why I gave you a couple days.
Okay, yeah, I was gonna say I might not make it in time
Right.
before Monday.
You'll have
Depends on
48
how long
hours
they take.
upon your release.
Right, thank
All
you,
right,
sir.
thank you, ma'am. All right, Mr. Etheridge, you're all set.
Thank you, Your Honor. Have a good day, good weekend.
You too.
Your Honor.
Yes.
Mr. Mauer, who's scheduled for prelim.
Do I leave?
Yes.
All right. All right, let's do Mr. Mauer. And then we can start the Williams.
Correct, yes.
All right. I should give my staff a break, but we'll do it after the witness testifies, since we know that. All right, so we're on the record in docket 23-03495. That's people of the state of Michigan versus Justin Mauer. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Thank you, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. Mauer, the gentleman who stands to my right.
And sir, you are Justin Mauer, is that correct?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination in the matter. Ms. Wilson, how we proceed?
Thank you, Your Honor. There was some information that was discovered by defense counsel just moments ago that may influence the plea offer that we had originally made in this case. So we would be requesting a brief adjournment to check on it and to renegotiate.
All right, and so for continued negotiations in that, is that a fair statement, Mr. Palmer?
That's an absolutely fair statement, Judge. There is some moving part. I don't want to go into details, but there's some moving parts regarding this case. I will acknowledge that the witnesses did appear today, so it's not based on that, but there's some moving parts. I think further negotiations are appropriate. My client is prepared to waive his right to have his exam within the 21 days. Certainly, we're not waiving the exam. What I would ask the court is that the court give us a date, I don't know, at least 2 weeks out, any time after that. 2 weeks or any time after is fine. There is a very strong possibility this case may resolve without having to run the exam. So certainly if we can get to that point, I will advise Ms. Wilson and she can call off any witnesses.
Perfect. All right, thank you. And that's a fair statement, Ms. Wilson.
It is, Your Honor.
All right. May I inquire your client of his waiver of the 21 days?
Of course, Judge.
All right. Mr. Mauer, you understand that you have a right to a prelim within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You, of course, are represented by attorney Paul Palmer, and he would be present to cross-examine any witnesses, contest any charges brought against you by the people of the state of Michigan. It's my understanding it is your wish today to waive your right to a prelim only within that 21-day period. You wouldn't be waiving your right to a prelim in general. And you'll be waiving it only within that 21-day period so that Mr. Palmer can get more discovery and continue negotiations to zealously represent you on your behalf. Is it your wish today to waive your right to a prelim within 21 days?
Yes, sir.
Okay, thank you. And is it, do the people also waive their right?
We do, Your Honor. Thank
All
you.
right. I find the waiver of the prelim to be knowing, voluntarily, and accurately made. We will set the prelim out. So the waiver of the 21-day rule is been completed, and we will set the adjourned prelim out
February 22nd at 9.
February 22nd. So that's right within 2 weeks.
Should be 3 weeks.
Oh, today's the 2nd.
Yes.
We're good. We're
Okay,
good.
just checking. I'm not math 1,000 either.
Oh, February, look, February 22nd, what time?
9, please.
9 o'clock. So please keep in contact with your attorney, Mr. Palmer. We've reset it for February 22nd at 9 o'clock. Okay, sir?
Thank you, sir.
All right. That's all for the record in that file. Thank you, everybody, for your patience.
Yeah.
Oh.
I mean, I have a sort of. I do have it. Also, all right.
All right, so we're on the record in docket 24-00105. That is Vashawn Williams. People of the state of Michigan versus Vashawn Williams. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Goodrich.
Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Williams, who's standing to my right.
And sir, you are Vashawn Williams, is that correct? Thank you. This is the time set for a preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. It's my understanding that Mr. Williams will be wanting to run this exam. So the people are prepared. We have our witnesses.
All right, and your first witness is the witness that we want to make sure we get on.
Correct, Your Honor.
And
Yes.
we might take a little break afterwards, just so that, give my
So
staff a
no-
little
yeah.
break, okay? All right, are there any matters to come to the court's attention, preliminary matters regarding sequestration or anything along those lines?
I believe just we're stipulating to the felon status.
Yes, it's my understanding they have the documentation for that, so we will stipulate to that at this time.
All right, so stipulate to the previous felony status. And is there a date on that, on the previous felony status?
I believe it was 1999. I have to. It's one of them. There's
All
a
right.
couple.
The most recent one on the habitual offender notice was from December 9th of 1998.
Okay,
Oh, 98, okay.
all right. I will leave the witnesses to counsel since you know your case better than the court does. And if you see anybody that should not be in the courtroom watching another witness's testimony, go ahead and let me know, and we'll enforce the sequestration order.
Who is the individual that came?
That is his sister.
Okay, all right, then we're good.
Okay. All right, Mr. Goodrich, anything from the defense concerning preliminary matters?
No, Your Honor.
All right. Counsel, you may call your first witness in the prelim.
Thank you, Your Honor. The people would call Anisha Taylor. She's in the bench here. She's got a team.
All right, Ms. Taylor, you can come forward. You stand right in front of me and state your first name and your last name and spell them both for the record.
Lanisha Taylor, LANIESHA, Taylor, TAYLOR.
Perfect. Please raise your right hand. Do you solemnly swear or affirm to tell the truth, all the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right, go and have a seat in the witness chair. Talk into the microphone, that's for recording purposes, and then project as best you can to the back of the courtroom. All right, ma'am?
Okay, yes,
All
sir.
right. All right, Ms. Wilson, when you're ready, you may proceed.
Thank you, Your Honor. So Ms. Taylor, I just want to start out today. We had a discussion that you were not feeling well, correct? Okay, I just want to.
Is that a yes, ma'am?
Yes.
Okay, thank you.
No, I just want to clarify, when you say you're not feeling well, you don't mean that you have any sort of cognitive impairment today. Okay. With that being said, Your Honor, I'm just going to proceed.
All right.
So, Ms. Taylor, I'd like to bring your attention back to January 12th of 2024. Do you remember if you had occasion to meet with the police that day?
Yes.
Okay, and where was that?
So talk into the mic so the,
This one?
yeah, that mic right there would go right to the court recorder.
Yes,
Okay, and where was that?
at my home.
And where is your home?
My home is 515 Shepherd Street, Lansing, Michigan, 48912.
Okay, and is that in Ingham County?
Yes.
Okay, now what led to the police arriving at that residence that night?
I was just angry. And I was angry
Okay.
about what was going on.
Mhm. And were you the one that called the police? Okay, did somebody else call police?
Mhm.
Do you know who?
I think it was the defendant,
And what's his name?
Deshaun Williams.
And how do you know him?
He's my boyfriend.
Okay.
On and off.
Okay, so you know him pretty well.
Yes.
You know what he looks like?
Yes.
Do you see him here today?
Yes.
Can you point him out and describe something he's wearing?
He's wearing black.
Okay, can you be a little bit more descriptive? Maybe indicate where in the courtroom he is?
Oh, he's wearing black and he's sitting in front of the courtroom in the, on the desk.
Okay, Your Honor, for the purposes of preliminary exam, I'd like the record to reflect that the witness has identified the defendant.
Any objection, Mr. Goodrich?
No, Your Honor.
Without objection, for purposes of prelim, the witness has identified the defendant.
Now, Ms. Taylor, was there something that occurred that led to the police being called?
Yeah,
Do you remember what that was?
well, he was talking to somebody, a female, and I was just very angry.
And did you guys get into an argument?
I wouldn't say an argument, we just was talking, and I just told him I didn't want to talk to him right there.
Okay.
Yeah.
Do you remember anything else happening that night?
No, well, no, I really don't remember. Everything happened so fast. I really don't remember what happened.
Okay, at some point, did Mr. Williams go into your residence?
No.
No, okay. I have nothing further for this witness at this time, Your Honor.
All right, Mr. Goodrich.
Thank you, Your Honor. Ms. Taylor, do you own any firearms?
Yes.
How many do you own?
I own 2 handguns and a shotgun.
Okay, and are they all registered to you?
Yes.
On this occasion, did you ever see Mr. Williams in possession of a firearm on this occasion?
No, both of mine. No.
Your Honor, I have no further questions.
All right. Any redirect, Ms. Wilson?
Briefly, Your Honor. Now, Ms. Taylor, I just want to clarify, when Mr. Goodrich said, was he in possession of it? Was he physically holding a gun at any point? No, okay, nothing further, Your Honor.
May this witness be excused from the people?
She may, Your Honor.
From the defense?
Yes, sir.
All right. Ms. Taylor, thank you for your appearance today. You're excused.
Thank you, sir.
All right, let's take 10 minutes to let the staff break, and then we'll go on the we'll go back on the record in about 10 minutes.
Appreciate your patience.
You can run to that or something else. He does do that.
The boy on Hangman just emailed me, he had work this morning.
He said the same thing.
Again,
Yeah, he said the
and
same
he
thing.
doesn't care about the additional charges, he just wants money for the gun. So you're not getting
I
money for
think
the gun,
he gave
because
the
the
gun.
charges with this.
Yeah, he's on the.
Thank you, appreciate it.
Sounds like he gave him the gun. Second, the last excuse was,
Then get
I
work,
worked.
they're holding up last
so
minute.
I shouldn't have reissued it.
I swear I'll be there.
Okay, yeah, that's literally what he said. He's like, I'll make
I
sure.
will be so, whatever.
I don't know, I was trying to-
He's got it, this guy's got it.
This is a really messy gun case with like the party and like the weird facts.
Yes,
And
but
the
he's
next
also
day-
got like a fifth in the meth possession.
And that gun's like
24-00105. And Ms. Wilson, you may call your next witness.
Thank you, Your Honor. The people would call Officer Tristan Brown.
There were some guys, but I don't know about it.
All right, Officer Brown, I'm gonna have you come up here. Please stand right there. Please state your first name and last name and spell them both for the record.
Officer Tristan Brown, TRISTYNBROWN.
Perfect. Raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Okay, go ahead and have a seat at the witness chair. Talk into the mic for recording purposes. And then if you do your best to project to the back of the courtroom, just so we can hear you. Ms. Wilson, when you're ready.
Thank you, Your Honor. Officer Brown, are you currently employed?
Yes, ma'am.
And who are you employed with?
Lansing Police.
What's your job title?
I'm a patrol officer.
And how long have you been a police officer?
Almost a year, say about 7 to 8 months now.
Okay. And have you been with Lansing Police that entire time?
Yes.
Okay. Now I'd like to take your attention back to January 12th of 2024. Did you have occasion to respond to a call at 515 Shepherd Street?
Yes, ma'am.
To the best of your knowledge, is that in Lansing?
Yes, ma'am.
Ingham County?
Yes, ma'am.
Michigan?
Yes, ma'am.
Thank you. So what was happening when you arrived at the scene?
When I arrived on the scene, officers were already on scene. They separated the parties. One officer was talking with one of the victims. The other officer was looking for the shell casing of the front of the residence.
And what was your role in the investigation?
So one of the officers, they went inside the residence because they had to clear the residence first. So I just stood by and Mirandized the person that was in the patrol vehicle at that time and got a statement.
And were you able to obtain a sort of identification from that person?
Yes.
And what was that person's name?
Bashan Williams.
And during your interaction with him, did you get a good look at him?
Yes.
Do you see him here in the courtroom today?
Yes, I do.
Can you point him out and describe something he's wearing?
He's right there with the black coat on.
Okay. Your Honor, for the purposes of preliminary exam, I would request that the record reflect identification.
Any objection to the witness identifying the defendant for purposes of prelim?
No, Your Honor.
Thank you, Mr. Goodrich. The witness has identified the defendant.
All right. Now, in the course of your conversation with Mr. Williams, this was, you said after you Mirandized him?
Yes.
And what procedure did you follow for reading the Miranda?
I read the LPD advice of rights.
And is that standard policy for LPD?
Yes.
Okay. So in Mr. Williams' explanation, did he at any point indicate that there was a firearm involved?
Yes.
Did he at any point indicate that he was physically holding a firearm?
Yes.
Okay. Did you find a firearm?
I did not find a firearm. Officers that were already on the scene already secured the 2 firearms.
Okay. I have nothing further for this witness, Your Honor.
Just a clarification. So firearms were found on the scene?
Yes, sir.
Okay. Mr. Goodrich, you may cross-examination.
Thank you. Officer, were either of those firearms registered to Mr. Williams?
No, sir.
When you showed up and you were talking with Mr. Williams, was he in possession of a firearm at that time?
No, sir. He was already detained in the back of the patrol car.
Okay, so you never saw him in possession of a firearm?
No.
And you advised that he, at some point, had stated that he had been in possession of a firearm?
Yes, sir.
And did he indicate that he was retrieving that fire, or are you familiar with who was the person who called 911 on this occasion?
Not at the time. No, sir.
Have you since learned of that?
Not that, no. No, sir.
And okay, when Mr. Brown made a statement to you, and at some point, did he state that a gunshot went off behind him?
Yes, sir. When I was receiving his statement, sir, he advised that he had a firearm from the nightstand going down to put it in his vehicle. The victim was behind the accused, and he heard a gunshot go off.
Okay. Did he advise you at some point that the dispatch person at 911 had told him to secure a firearm to keep everyone safe?
Your Honor, I'm gonna object to this as it's hearsay. It's not a party opponent admission. So the best evidence would be for the defendant to testify to this.
Response.
Your Honor, the officers testified that Mr. Williams made a statement to him regarding being in possession of the firearm. I'm just simply asking if he ever learned why he was, from Mr. Williams, why he was in possession of a firearm.
That's a different question. So I'm going to sustain the objection as to the hearsay for what was told by dispatch to. I think you can clarify though the statement made from your client to the witness, since he's already testified that your client, and that is admission of a party opponent, testified that he was in possession. You can make clarification of that, which that would be the nature of your question, I think. Okay. So I'll allow you to rephrase and I'll sustain the objection.
Okay, officer, did you ever learn from Mr. Williams why he was in possession of a firearm?
When I talked to Mr. Williams, when I was getting his statement, he advised that when he returned back to 515 Shepherd, he went and called 911. He went and then pretty much he said that when he went upstairs to the nightstand to retrieve the victim's firearm, he went down and put it in the truck because that's what dispatch told him. So then he said that he went to the vehicle, dropped the firearm off in the trunk of his vehicle, and then the victim grabbed the firearm from his vehicle and brought it back inside the residence.
And
from his statement.
And other officers recovered the firearms?
Yes, that to my knowledge.
Now, was it you or Officer Muller who had recommended seeking reckless discharge charges against Ms. Taylor?
Your Honor, again, I'm going to object here to this line of questioning. That's not a charge here. So I don't think it's relevant to this case.
In response to relevancy.
Your Honor, I was just asking him based on his investigation, if it was him. It may not have been him. I'm not even sure if it was him.
I do not recall that, sir. I was not the primary officer.
So the point is moot, I guess, on some level. So the objection's overruled as to relevance because he has no testimony concerning that matter. Okay. You may proceed, Mr. Goodrich.
Right. Your Honor, no further questions at this time.
All right. Redirect Ms. Wilson.
None, Your Honor. Thank you.
May this witness be excused from the people?
You may, Your Honor.
From the defense.
Your Honor.
Yes, Your Honor.
All right. You're all set. Thank you for your appearance today.
Thank you, Your Honor.
Any further witnesses from the people, Ms. Wilson?
None, Your Honor.
Do the people rest? All right. Mr. Goodrich, any witnesses or any presentation of evidence today?
No, Your Honor.
All right. Motion for bind over, Ms. Wilson.
Thank you, Your Honor. The defendant is charged in this matter with felon in possession. In our preliminary matters, we did stipulate to Mr. Williams' felon status. To my knowledge, there has been no petition to reinstate his firearm privileges. So at this point, he does not have the reinstatement of those rights. So today we heard testimony from Ms. Taylor, who said that she just didn't really remember what had happened that night. And she was angry and things got out of control. And then we have testimony from Officer Brown, who spoke directly with the defendant and who identified the defendant as the person he spoke to, who stated that he had physical possession of the firearm at some point during that night. He took it from the nightstand upstairs down to his car. For probable cause purposes, the element of the felon in possession has been met, as he did in fact possess a firearm as a person with a felony. He has also been charged with a felony firearm, which requires that he was carrying or possessing a firearm during the commission of a felony. The felon in possession is the predicate felony in this matter. Again, there was testimony that during the commission of the possession of the firearm, he was in possession of a firearm, which I understand is redundant, but that's where we're at. felon in possession is not excluded from the felony firearm. I know charges like carrying concealed are excluded, but there has been specific rulings that the felon in possession is not excluded from the felony firearm charge. So in this matter, the people have sustained their burden by a probable cause on both counts, and we respectfully request bind over.
Mr. Goodrich.
Thank you, Your Honor. Your Honor, while the prosecution is required to show the elements of the affirmatively of each of the charges that he's being charged with, a prosecutor also is required to show that a defendant did not act in self-defense. Now, typically, this is a subject that is not left to the district court because it's essentially a balancing of facts. But in this situation, we don't have a balancing of facts. We only have the statement, the only evidence that has been admitted against Mr. Williams being in possession was Mr. Williams' own statement, and his statement clearly states that he was, what we heard on the stand is that he was informed by 911 that he should place any firearms into a secure area to keep everyone safe, that he was acting in self-defense by protecting himself by taking guns, not pointing them at somebody, not assaulting somebody, but putting them in a secure place like the trunk of a vehicle. That is not disputed today. There is also is required to show that he didn't create the situation by committing a crime in the first place. For instance, if he had, the old saying, if you start attacking somebody, then you can't, and they pull a gun, you can't claim self-defense. There's no evidence that that occurred in this situation. We heard that there was an argument over Mr. Williams being around another woman, that Ms. Taylor was very upset about that. And then again, all we go back to is the testimony that we heard from him, from his statement. We also heard testimony that there was a shot fired behind Mr. Williams, likely by Ms. Taylor in this matter. So when the court looks at this, again, there's no facts to the contrary. This is 100% Michigan criminal jury instruction 7.25, self-defense as to felon in possession of a firearm that is allowed, and the prosecutor has not shown any evidence that this was not self-defense. We would ask that the court deny bind over on both counts, Your Honor. Thank you.
Thank you. Response?
If I could have just a moment, Your Honor.
It's 7.25.
So, Your Honor, I'm admittedly not finding the oh, I was looking at the wrong one. So, Your Honor, I don't necessarily agree that the prosecution has to prove that this was not an act of self-defense. I believe that is an affirmative defense to the charge, which the defense is entitled to present as a defense. But again, that is not an element that the people have to prove. And at this point, it's also something that's up to the trier of fact. And there is case law on when there is an issue up to the trier of fact that the court is obligated to bind over. So I would renew my request to bind over.
Thank you.
Your Honor, if I may make a brief reply to that. Jury instruction 7.20, the burden of self-defense is that instead the prosecutor must prove beyond a reasonable doubt at trial that the defendant did not act in self-defense. It is a burden that is 100% on the prosecution to show, Your Honor. Thank you.
Thank you. So this is the testimony that the court does have today from Ms. Taylor, who indicates that she did call police and they did respond to 515 Shepherd Street in the city of Lansing, Ingham County on January 12th, 2024. So the location and venue and date have been made. I don't think there's any confusion as to the ID concerning the defendant. I've listened to the motion and response to bind over for motion considering the elements of the crime. And I'm somewhat familiar with some of these issues. Everything, so, and the standard for district court is probable cause. Probable cause evidence that location, offense, venue, ID, and date have been met at a probable cause level that would bind this case over to circuit court is the request for the motion to bind over. Self-defense is a defense as to the conviction, reasonable doubt. Of course, the court can only bind over on legally admitted evidence. And that's been, so this is what the court has. The court has location, venue, ID, and date from Ms. Taylor, and then some hearsay inference that she caught the individual, the defendant, with another woman. And this is just the nature of this. I don't expect the defendant to take the stand and indicate that he felt compelled to defend himself on some level because there was, but that's what the case law would require in reasonable doubt standard, that the defendant somehow says that his actions were justified in defending himself. And he can't do that today, and he shouldn't do that today. Mr. Goodrich is right. You shouldn't be put on the stand. But so the what's left is, was this a justified possession? And that goes to the credibility of whether the dispatch person said to him, and that's also a credibility issue as to whether to take the gun and put it down and put it in the vehicle, which somewhat happened and somewhat didn't, depending on who you believe here, because the officer indicated that the defendant did that, which places him in possession of a firearm. Yeah, but he said he was told to do that by dispatch, but dispatch doesn't know his status. But then he put the car he put the gun in the car, and the gun was retrieved by the victim in the matter, which may go to the self-defense claim, but I don't know, because as Ms. Taylor indicated, that nobody was in possession of a firearm that day. So at a probable cause level, I do believe the minimum probable cause has been met, that the elements that Mr. Williams was a prior felon, has not met the requirements for being off of any requirements to own a weapon along those lines. He is in possession of a firearm. Therefore, I believe that count one has been made by a probable cause level to possess a firearm when eligible to do so, because he had been convicted of assault GBH on a previous occasion and more than 4 years or more, and the requirement for gaining eligibility had not been met. I believe that's been met at a probable cause standard in count one. Count two, as counsel indicated, it really depends on the count one determination that they were in possession of a firearm during the commission of being in possession of a felon, which is the allegation in count one. So I believe that is met at a probable cause level. It would seem to me that this is exactly the issue that would be bound over as to the trial court to be addressed at a beyond a reasonable doubt standard by the jury trial. It will also seem to me that this is exactly why, as knowing your status, you'd be very careful about being around any weapons or being around anybody who has a weapon because of the status. But that's just my commentary on the issue. That doesn't lead to the bind over. I believe that location, offense, venue, ID, and debt have been met on count ones and count two, and I will bind over on a probable cause determination to circuit court to be bound over as charged. I would indicate that Mr. Goodrich is absolutely right. Self-defense is a defense to the count one felon in possession, and that's pursuant to case law. So I would indicate that counsel is right on that matter. This is bound over to circuit court. So Mr. Williams, your next date will be in circuit court. So make sure and keep in contact with your attorney, Mr. Goodrich. Probably in the next 2 weeks will be the arraignment in circuit court. And I don't know if something will be filed in that regard, so you don't have to show, but you'll get your next date in circuit court from your attorney, Mr. Goodrich. Anything else for the record in 24-00105, Ms. Wilson?
Just one thing, Your Honor, just for the sake of clarity and Your Honor might have stated it and I missed it, but there is a habitual offender fourth notice on this as well. I just want to clarify that that's following the charges as well.
That will also follow, that's my understanding. This, Mr. Goodrich, is that your understanding?
Yes, Your Honor.
Yeah, that would follow to be bound over. You don't have to prove that, but that'll be, that notice requirement will be part of the circuit court complaint. Anything else, Mr. Goodrich?
No, Your Honor.
All right. Your next date will be in circuit court. Thank you for your appearance today. You're all set. You're all set, Ms. Wilson.
Thank you.
Okay. Thank you, Your Honor.
Thank you. I think that's it, Ms. Wilson.
I think so.
I think that's our docket for today.
I thought I saw somebody, but it might have been a jail person just turning.
If there's another case, I'm not aware of
I
it.
think there was actually an attorney. I looked at the badge he had
Oh.
on. I think he was coming in to do a,
Oh, to do like an
like an interview with a
Okay.
client. And that's when they turned it. I'm pretty sure that was an attorney based on the little slip-on badge they had.
I'm assuming Mr. Goodrich wants the transcript for
I would
that.
assume so.
Yeah, I think.
We did sign a
He should
transcript
be
request.
back any second. His stuff's still here. There's somebody left a hat.
I think you can get a copy of that.
Ah.
Zoom.
Let me.
Happy to hear that they got mad.
Very much so.
Discharged.